thing into the record from the executive director?
No, I don't think so. I think let's just do a roll call, make sure we have quorum.
Present.
Blair Parker,
Here.
Susan Ballard, Brian Tibbs,
Here.
Kathy Ware. We have a quorum.
Thank you. I don't think we have a lot on the agenda this morning. I believe what we were going to further discuss the. I'm sorry, I don't have the number, the legal number for that, but the rollover hours. And if I could, I think can I just turn this over to legal and let them explain what our situation is, or how do we want to handle this?
Sure, that's fine. It's Rule 0120-5. It's on page 3 on your iPads under the board meeting.
I'm sorry, we're having technical difficulties over here. What page was that again? Page 3?
I believe it's on page 3. Can I have an iPad, you think?
And where are we on page 3? I'm sorry.
It should be, and Wanda's grabbing it for me, it should be under your board meeting, under library. There should be a,
Oh, I've got the page. I'm just wondering.
is that the rule? Do
Page
you see the
3.
rue?
It's a bunch of rules.
Yeah, this is starts off with amendment to
Yep,
rule.
that's it.
0120-01-.08.
That's it.
That's it.
And so one of the things we need before legal talks to you a little bit about this process is, and some of it's for my clarification, because this predates me. I think it predates some of it. I know it predates. Okay. So what we need to discuss is the necessity for this rule, specifically the necessity for no carryovers on the PDHs. That's something that I know we're going to have to be able to support as why we're doing that. And so that's one of the main issues. We also have the other issue that because this has been in limbo for a while, I think since 2017, it made some of the language stale on what was fair as far as when it would stop. I think it was projected that it was going to be more than fair based on a 2021 timeframe, but now that we're almost to 2020, it's not equitable for each person that's carrying over or renewing. So those are the two specific things I think we really need to discuss on this committee is what's the necessity, and then what time frame, if there is a necessity, what's the time frame?
Okay. If I could, I will try to refresh our memories. This rule change was brought before the board by the architects. And the reasoning behind this, and I'll make this short and sweet, is that what we are trying to do, given that we have 54 jurisdictions that we can be licensed in, each jurisdiction is basically different, of course, because of the state rules and laws, and so what NCARB was trying to do and is trying to do and has been successful doing so far is getting the states to adopt sort of a universal continuing education process, which is primarily HSW, health, safety, and welfare hours. Most states require 12, some 14, some 16. So you really have to keep up with the individual states you're licensed in, and you have to know the rules and the laws and all the things that we're supposed to do to be licensed professionals. So part of the process of getting everyone in line, with the exception of number of hours, is there was a lot of confusion about the carryover or the rollover hours. And the majority of these states that have had them, and I'm sorry I don't know if there's any left besides Tennessee, the carryover hours are not allowed in certain states. So if I want to be licensed in Kentucky, as an example, which is just a random state, and I don't meet their licensure requirements because Tennessee's are different and allow me to practice in Tennessee. Well, therefore, I cannot get licensed in that state. And that's a hindrance to our ability to practice on a national basis, which a lot of our firms do. And a lot of the firms in the state of Tennessee practice on a national basis. And I know we have individual practitioners who don't practice outside the state. And that's probably some of the people that object to this because it's easier to maintain your continuing education credits because you can roll back for so long for so many. So our reasoning, excuse me, as the architects, is simply to keep it simple for us to practice. I'm licensed in 22 states, so I understand the difficulty in some states to maintain or get your license, and it just seems to make our practice easier, which is in some instances it's difficult enough without having to do that. So that's the idea behind it. Now the time frame was to give the rollover participants enough time to use their hours, with the understanding that if you don't meet the national criteria for those states, it doesn't matter how much rollover time you got, you're not going to meet the criteria. But for those who, again, are practicing on a individual state basis, it didn't penalize them. So, and you know, given the fact that it's got installed in committee or wherever it's been in limbo, I like to say maybe it was in the cloud. I don't know, but everybody has one, right? So that is part of the reason that the language has gotten stale. And I know there have been some comments, or I've been told there have been some comments by some of our fellow architects that they don't like this idea. And I understand that, but for us to move forward and be competitive on a national basis, this is important, I think, to us as architects. Now, that I don't know where a magic cutoff time would be. I think that at that time that was enough time, and if we need to roll this forward, if we need to clean up the language a little bit, I think it'd be easy enough for us as a board to say, okay, we'll extend this time frame for 2 years. And I'm just using a number because, you know, that's just it's an arbitrary number if you ask me. You know, I would say 2 years would be enough because that way you can plan ahead. So that's kind of the background from my understanding and the architect's understanding. And Brian, if you have anything to add to that, please do.
No, actually, I'm glad you kind of brought me up, reminded me kind of this, because we talked about this
4 years ago.
Yeah, it was a long time ago. So I thought the rollover I thought we'd already had approved this anyway. So, but I do agree, though, getting more in line with the other states will help us all. That even people who feel like they are not going to ever work in another state, all of a sudden they get that opportunity and find out that they're, you know, the way they have been doing their CEUs has been incorrect. So anyway, that was a good summary. I appreciate it.
Thank you.
Yeah, and I will say that really helps me in understanding, because we're receiving a lot of comment back, you know, against this change, but it's helpful to know like why that might be the case. And I will say it is well received up on the Hill for, you know, allowing reciprocity in Tennessee. That's something that we always get asked about, and that we're keeping up with the professional, you know, industry trends, and that, you know, we're making it better to do business in Tennessee. And so that is a great angle that we have on that. This is just one suggestion I have, but if you guys are comfortable, I could reach out to I think it's at NCARB and kind of get a feel for maybe how other states have moved forward when they have gone from carryover to not having this, and get some of that language, and I can present that. If you guys are okay with that, I don't mind spearheading that.
Oh, by all means, we recommend it. Yeah, we would recommend that actually, because if we're going to fall in line with that, then that would be fantastic if we could do that. Thank you for suggesting
And with
that.
that background, I mean, that really helps me. And then we can yeah, hopefully move forward on it. So yeah. Also, I will say, just for everybody here, I have to step out for a motor vehicle meeting. It's an emergency meeting, but I'll be back, and Stuart and I are going to kind of trade off. So that's at 9.
Are there other comments from the other members?
I would just like to add, I did not have an official statement from the Tennessee chapter of ASLA regarding this. I personally believe that it's a good idea, and I know that we as a state are trying to be user-friendly, you know, and that doesn't necessarily mean make it easier to become licensed or to soften our requirements. I tend to like the idea of us being on the more progressive side of the needle, you know, of the gauge, than just the opposite. But it would seem to me that if we get this passed, it cleans a lot of things up. It helps not only with staff, it would actually help with individuals over time. It's just there are some people that wait to the last minute or don't want to go through continuing education, and I think we'll continue to have troubles with those same people. But that's my opinion at this moment. But while we do have this reprieve, I will get with Tennessee ASLA and get their official input for that.
I haven't been able to go to any of the NCARB meetings or anything like that yet, but has it been presented that there's a correlation between carryover credits resulting in complaints or lack of knowledge by architects, or is there some sort of issue there?
Well, actually, the issue is that a lot of states that were licensed in on a national basis on a calendar year, and I just renewed. I don't remember what state, but it's you have to have the 12 or 14 the CEUs that are in health, safety, and welfare from January 1 through December 31st. Nothing carries over. If you are accustomed to carrying over in your home state, and you may be licensed in that state, and you can't renew your license because you didn't meet the criteria, you're in violation. You get reported. You know how this works. It telegraphs all the way down. Or if you, like Brian said, if you are fortunate enough to get a commission in Ohio or wherever, and you can't meet their criteria to be licensed, well, we're suffering as architects to be able to practice nationally, and not just people wanting to come into Tennessee and practice, but we should be able to go out and practice in any state that we want to practice in, and not our state rules and laws hold us back from doing that because we're not current. That's one of the big issues. So when they stop the rollover, then that puts us behind the 8 ball.
And there is an encouragement that they want us to stay up on this. We really don't want to keep it as a nuisance. We really want to encourage our profession to want to get these credits yearly and not trying to stack up and roll over. So it's more of keeping our profession more current. So that's a little bit more kind of also towards your question.
And also, if you go back and look at the number of hours, if I'm doing 12 HSW hours from J1 through D31, then I'm staying up on some issues that do affect the health, safety, and welfare. I'm not trying to get a credit for going to Italy and doing a watercolor.
Yeah.
Now that's a lot of fun, I might add, but I'm not trying to get a credit for it. So, but it's just a discipline, a national discipline, to be current with our profession, and do what we're charged to do by law, is to protect the health, safety, and welfare of the public. So I think that's another point that could be used to. It's a true point. We're not stretching anything by any means here. So.
Well, I appreciate your all's patience on this and explaining and giving the background. I know it's been in the cloud, we'll call it, for a little bit.
Yeah. Well, thank you for your assistance.
And I definitely want to get a move on it for you guys. So
Okay. Well, we appreciate
we'll work on
that.
I need a motion to, just since there's action needed, so that we can move forward with investigating the NCARB and then ASLA. And I don't know if you just want to do just a kind of a general motion for more investigation on other states and then the more national organizations as well.
I'll make the motion that we request legal look into NCARB and CLARB and maybe on the engineering side to see what requirements they have and sort of where they're going with that. So that wasn't a very concise motion.
Make sure you're on the record there.
Yeah, on the record, Kathy, I believe you had comments.
Yeah.
Yeah, he seconded, and
Mr.
it's open
Tibbs.
for additional discussion.
So I just want to speak with regard to the engineers. I think we were just kind of
Hey, Kathy, I think your speaker's not on. Is it mute? Your little
Somebody
guy's
hit
not
mute.
lighting up.
You're
There
right.
you go.
There you go. Sorry. Anyway, we'll go along with that in terms of whatever the architects want to do. That was something that was good with us. Makes everything more streamlined, makes it more consistent for staff, et cetera, but there wasn't any real restrictions on the engineering side on that. So that's fine with us. Rather than just saying more research, could I ask that we have a motion that is has like a deadline that says by the next meeting that staff will report back or something like that, so that we don't forget where we were, because 2 months pass and sometimes we forget because everything goes to the cloud.
Could we ask staff to give us some idea what that might be a reasonable amount of time?
I mean, I can definitely have something back to you by the next meeting. So.
Okay. All right. Do we need to put that in a motion, or is that just going to be on record?
No, you can amend it if you'd like to amend the motion.
Friendly amendment?
Yeah.
Amendment.
Approved.
It doesn't even have to be friendly.
A mean amendment.
We like to keep it. We like to keep it friendly here. Thank you so much. So we have a motion and an amended motion, and do we have a second?
Yes.
All right, we have a second. Can we call for the vote? All in favor of the motion?
Aye.
Aye. Opposed? Motion carries. Thank you.
Thank you, Maria.
I'll be back.
Okay.
All right, Mr. Chairman, I think that's all the business. If you just need I think you need a motion to adjourn.
Yep. Can I get a motion to adjourn?
So moved.
So move. Get a second?
Second.
Kathy, or Blair, excuse me. We have a motion, a second. All in favor? Aye.
Aye.
Opposed?
Aye.
The meeting is adjourned. Thank you for being here.
Thank you, guys.
Sorry we got started late. Holiday season.
Yeah, pause it. Who is it?
Good morning. Great. Good morning, everybody. Let's call this meeting to order. Today is Thursday, December 12th, 2019, and this meeting is being held at the Davy Crockett Tower, Conference Room 1A, 500 James Robertson Parkway, Nashville, Tennessee, 37243. Welcome, everyone. Let's have roll call.
Susan Ballard. Robert Campbell. Ben Brickta. Ricky Bersai.
Here.
Blair Parker.
Here.
Brian Tibbs.
Here.
Rick Thompson. Frank Wagster.
Here.
Kathy Ware.
Here.
Alton Heathcote.
Here in tribute to Wanda Garner and Francis Smith. Thank you.
Stephen King.
Here.
Thank you.
Quorum.
For your information, our new public board member, Ben Brickta, was not able to be here today. Had anticipated being here, but something came up that he was unable to. So he sends his apologies to everyone. Acknowledge our guests in the room. It looks like we have one.
One is on the interstate.
And one's on the interstate. Okay.
Mr. Campbell is available by phone, and we may want to just pause for a moment, get him on the phone. Actually, if you would like to. Okay. You can pause it real
We
quick.
have to.
If we want the meeting to go longer, we do, yeah.
He is now ready? Tennessee as they are in Nashville, Tennessee.
Sorry,
Right.
I just got done having country ham and sausage, so they're much better here.
That's great. Okay, we are in our board agenda. We introduced Ben Brickta, who is unable to be with us today, and he will be here for our next meeting. He is our new public member. Any announcements we need to make? I would like to add one thing. We were sent a revised list, board member list. If hopefully you've had a chance to go through that to make sure all your information is correct. If not, please just redline it and get it to staff to make sure that the corrections are made, and they'll get it back out to everybody. So thank you very much for assembling that. I would also request a copy of or another round of the committees.
Sure.
Given what happened earlier, it might be a good idea. So, for me, if for no other reason. Reviewing the agenda, is anything? Anybody have anything to add, subtract, anything on the agenda? CIDQ.
Yeah, I think just make sure you're not on mute. Just make sure you go on the record there. Your little light didn't light up. Yeah.
And that will fit where, Susan?
Just under, oh, thank you. When it says mute, that means it's not going to say anything. I am not a morning person, just so y'all know. And my husband is one of these 4 a.m. people, so we got to work this out. But anyway, I need to give a CIDQ meeting report.
Okay.
And it can follow after the director's report. So
We also there will be a change to the updated contact list to reflect Miss Ballard Gribble.
Thank
Blair,
Yes.
my esteemed colleague, Mr. Thompson, pointed out to me that in our roster, I'm listed as the chair, and I don't believe I am.
It's an opportunity here, Frank.
That's right.
Take this as an opportunity.
I'm actually planning a takeover.
Do you need a motion, Mr. Chairman?
That's right. Okay.
There on the director's report, there's one piece of financial information that Roxana gave me this morning that we just need to add. It's not on your iPads, but I'll pass it out to you all. And it has to do with the grants to Lipscomb that was discussed, the grant that was discussed at the October meeting. So I will be passing that out.
And that will fit under the director's report.
Yes, sir.
Okay. Thank you. Thank you. Anything else for the agenda? We don't need to take a vote for this, do we? It's just a revised, amended agenda? Okay, professional society reports?
I think really quickly, do you want to just make sure that we're all in agreement to use Robert's Rules of Order again for this year?
I believe.
I think we
yes.
have to do that.
Okay.
I make a motion that we use Robert's Rules of Order.
Second.
Discussion? All in favor?
Aye.
Opposed? Thank you. Okay. If you'll excuse me, I jumped a little bit far. Minutes from the October 2019
Yes,
meeting.
thank you. It's on page 12 on your iPads.
Hopefully you've had an opportunity to review that. I'm going to take a few minutes. Let's take a few minutes to review that.
Shit, what happened?
Mr. Chairman, I'd like to move that we approve the minutes of the October 4th board meeting.
Okay, we have a motion on the floor to approve the October 2019 minutes. Second. And we have a second. Any discussion? Seeing none, all in favor?
Aye.
Opposed? Great, thank you. Move to the meeting minutes for the November 19th, November 2019 board meeting. It's on page 30 in our iPad. Let's take a few minutes to review that real quick.
To approve?
Second.
Motion and a second to approve. Any discussion? Seeing none, all in favor?
Aye.
Opposed? It's passed. Thank you. Professional Society reports. I'm sorry. We're back up. Back up to the podium.
Good morning.
Good morning.
Morning.
Good morning.
Good morning. Casey Anderson with the American Council of Engineering Companies of Tennessee and the Tennessee Society of Professional Engineers. Apparently, I am speaking on behalf of everyone, though no one gave me a report. So we'll just hear about my stuff. The engineers were thrilled. ACEC just 2 weeks ago, the week before Thanksgiving, had our Engineering Excellence Awards. We honored 32 projects this year, which was the most we've had in ever memory that any of us can go back and see. So we're excited about that and hope to have several that also submit to the national awards from there. The day following, we did the first ever Senior Principals Forum, where we really focused on those top level folks in their firms and the unique needs that they have in terms of managing the people below them, which went really well. TSPE last week did a 3-day road show across the state, all on risk management, that were well attended. We had a day in Knoxville, a day in Nashville, and a day in Memphis. Those went well. We recently, right before the October exam, the week of the October PE exam, wrapped up our PE exam review course, which is a 10-week course leading up to the test. We had 16 people in there this time, and are looking forward to finding out how they did. That we tend to do really well, and with a few exceptions, have had 100% pass rates coming out of that class in recent memory. So that's exciting. Our leadership class, Leadership PE, will start in January. Those applications are due this Friday, and seeing a lot of good candidates coming through there. We're in the process of putting together a QBS coalition that will be we think, it looks like it will be ACEC, AIA, landscape architects, and we'll likely ask the surveyors to join us at the beginning of that as sort of a steering committee, and then grow it from there with other agencies and organizations that are supportive of QBS, and just to give us a little more teeth behind what we're doing, and have a have a bigger impact and be able to speak really with one voice, so it's not individually. I probably send out 3 or 4 letters related to qualifications-based selection a month, and just to have a bigger pool for that, I think will be nice. Oh, I'm so glad you're all here. Hi. Session starts January the 14th, so we're gearing up for that, and I'm sure Nathan will have a much more eloquent way of explaining how that's all going to work. But unless you all have any questions, I don't think I have anything else.
Thank you, Casey.
That's all.
Mr. Ridley?
Good morning, Mr. Chairman and members. I'm Nathan Ridley. I'm here on behalf of the Tennessee chapter of the American Society of Landscape Architects. Our news is obviously we pay close attention to the General Assembly, and as Casey noted, they'll start on the 14th of January. Probably the biggest news item is the House has a new speaker. You've heard me say before that all members are equal, but some are more equal than others. So who sits in that chair is really, really important to how the process works. And I think the House is in shall we say, desperate need of calm. So hopefully they'll have that. The budget process is ongoing right now. Governor Lee's putting his budget together, and he'll present that in early February. Some folks hope because, well, not because of the elections, but some folks think there will be a short legislative session. Revenues for the state budget seem to be coming in above projections, which is a good thing. On the landscape architect front, our executive committee met just a couple of weeks ago and huddled up, and we have a new president, Owen Harris of Memphis, Tennessee. We're excited about his leadership. And then Daniel Boucher is our president-elect, and he's working on our conference in Knoxville for 2020. And we're really, really excited about, in 2021, the entire the National Conference for Landscape Architects is going to be here in Nashville. So it'll be a lot of work, but it'll be kind of fun too. So that's all I have. Happy to respond to your questions, comments, observations.
And Nathan, if I may add, because I attended that executive committee meeting. The Tennessee ASLA is broken down into 3 sections. And the meeting was so well attended, and I believe we only had one person that was unable to attend. So it's amazing how well ASLA is communicating across the state. So kudos to you because you were part of that. Thank you very much.
Thanks, Tom.
Good morning, Mr. Chairman and members. For the record, I'm Don Baltimore, representing Tennessee Interior Design, Education, and Advocacy. Not a lot to report other than it's the end of the year again. It flies by fast, and it's been an enjoyable year working with all of you. Just a small report. I attended, along with Susan Ballard, the Council for Interior Design Qualification annual meeting in San Antonio, Texas this year, where they talked about several things: state of interior design, a lot of legislation around the country to deregulate professions, including those of us in this room who have professional licenses. There was talk there very briefly, and Susan will give you much more detail about CIDQ and NCARB studying exams together, a committee. And then as far as legislation goes, this coming 2020 session of the General Assembly, the Interior Designers Association does not have any legislation this year. We'll just be monitoring, see what happens, and also working with all of you other professions, any legislation of interest that arises. Oh, and by the way, unfortunately, Susan's term ends June 30th of 2020, and the Tennessee Interior Design Education and Advocacy has submitted 2 nominees to the governor's office for succeeding her after her term ends. And it may be spring or a little bit later in spring before we hear from the governor's office, but they're aware of our submittal and working it.
Thank you.
Thanks.
Questions? Comments? Great. Thank you all very much. Legal case report.
Good morning. Let's start with the legal report. Number 1, 2019-073-421. Respondent self-reported that he had practiced on an expired license. Respondent's license expired on February 28, 2018. Respondent explains that he had not knowingly practiced on an expired license. When he learned of the expiration, he immediately arranged for a licensed engineer to assume charge and make revisions to the plans respondent stamped during the expired period. Respondent lists 5 projects that he stamped while his license was expired. 2 are right-of-way plans for certain road interchanges and highways. 3 are construction plans for a trucking company and 2 state routes. Respondent has since applied and been approved for licensure on August 30th, 2019. Reviewed by board member Stephen King. Mitigating factors are self-reported. There are no aggravating factors. Recommendation is to authorize a civil penalty in the amount of $500 for practicing on an expired license and pass the laws and rules exam to be settled informally by consent order with authority to proceed to a contested case proceeding if the respondent does not agree to the informal settlement.
Any questions for legal? Seeing none, we have the case in front of us. Chair's looking for a recommendation or a motion. We have a recommendation before us.
There's no further comment. I make a recommendation that we move forward with legal's recommendation.
So we have a motion.
I'll second that.
Frank? Thank you. We have a motion and a second. Any further discussion? All in favor?
Aye.
Opposed? Motion passed. Number 2.
Number 2, 2019-07-0601. Complainant was in the process of reviewing a project that was being coordinated by respondent. During review of the second revision of the drawings, complainant noticed that an engineer seal had become nearly illegible. Complainant noticed the seal was dated April 20th, 2019. Complainant looked back at the first revision of the site plan and also noticed the engineer seal was dated April 20th, 2019. The first revision was dated June 24th, 2019, and the second revision was dated July 13th, 2019. Complainant also noticed that all revisions were made by hand on drawings that were originally created in CAD. Complainant reached out to the engineer that had stamped the original plans to see if he had made the revisions by hand, and he stated that he had not. The engineer stated he was shocked that it had been resubmitted after his original submittal, since he was in the process of working on the revisions to the original. Complainant later met with respondent, and during that meeting, respondent admitted to making the revisions to the drawings. Respondent is not a registrant. It's reviewed by Board Member Ricky Bursai. No mitigating factors. Aggravating factors are revised twice. No response received from respondent. Recommendation is authorize a civil penalty of $3,000, which comprises of $1,000 each for the 2 unauthorized revisions to the plans by non-registrant respondent and not for submitting a response to the board.
Heard the case. We have a recommendation in front of us. Any discussion before we go to a vote? Kathy?
Stuart, on your recommendation, you said a civil penalty of $3,000, which comprises $1,000 for each of 2 unauthorized revisions. So help me understand 2,000 versus 3,000? Is it 1,000 plus the 2? Is that what you're saying?
It's 1,000 for the first revision, 1,000 for the second revision, and then 1,000 for not responding to the board.
Okay, thank you. And has he never responded?
No.
Further discussion, questions?
A question for Ricky, because you've reviewed this. Do you mind? So were they significant changes that how much responsibility did this person take on in terms of new design work?
I don't know that I saw the whole sheet with all the handwritten notes on it. This was I think a public entity that reviewed the drawings as an owner and noticed all the handwritten notes, but I did not. I don't think I got the whole sheet. They were just the reproduction of the stamp on the sheet.
I guess I have a question for Ricky. Is there any, I don't know if you talked to anybody or anything or just read the review, but is this something this guy's done before or this person's done before? I mean,
I don't know.
It sounded like he got caught.
Yeah, it really seems so straightforward to me. When most of these cases are not straightforward. It takes looking at them for, but this seems so straightforward. And he admitted it when the complainant called him, and it looked pretty clear So nobody was talked to. I didn't talk to anybody to see whether this person had done it before. In fact, I mean, the respondent hadn't responded yet, so.
I want to make it 2 for not responding, you know, just, he wants it to go away, and I don't know. I jumped in front of Susan anyway, so.
I'm just curious, how's he stamping drawings if he's not a registered engineer?
Well, the respondent took the seal that was on the original set in order to make the revisions, just photocopied and.
He committed fraud.
Yes.
Okay.
Yeah, without the engineer's knowledge.
Okay.
Right.
You said he photocopied
Or
the
I
seal?
don't know.
You said
but
you didn't see it.
The clue is that the seal got blurrier and blurrier as the revisions went on, and so the owner said, "Hey, why is this so blurry?" and the dates don't match, and so I'm assuming that the respondent didn't have an actual stamp. They were somehow making a reproduction of the stamp that was on the original set to apply to the revised sets. It's doable. Yeah.
Further discussion?
I guess I think we're all struggling to make sure that this is
There's enough.
proper penalty. I mean,
Yeah.
if this is,
Well, I will say, I mean, when I looked at it, I came up with 3,000, a little bit different than Stuart did. His is, I'm sure, legally. I looked at it, there were 3 sheets involved. And in the past, we used to charge on stamp violations by the number of sheets. So I came up with 3,000. It could have been 6,000 because there was a revision involving 3 sheets, and, well, I don't know if it was 6. There were 2 different revisions on 2 sheets and 1 revision on 1. You could say it was 5 sheets and $1,000 each because there were aggravating factors, and it could be 5,000 because the respondent did it 5 times.
Kathy?
I guess, but I think what we're all thinking is this just going to be the cost of doing business for him, and he's going to do it again because he didn't respond to legal, or is this truly just an oversight, and this will be enough, and he won't ever do it? I think we're all looking at it from the standpoint of, is this going to be a deterrent for future equal behavior? So I guess I'm curious as to what this person's experience in the industry is. Are we talking about a person who has the potential to do this again many times over in the future? And again, is this just going to be a cost of doing business for him? He's going to write us a check and move on, and then maybe not, we run into it. Stuart, can you provide any insight or background on this, on the respondent?
I can't. He's not. I haven't seen this name in the past.
There are no previous cases.
There's no previous case on this person. I think that the city, who was the complainant, has put him on the radar. But I have no knowledge of this person.
So if it comes up again, the city, you're saying is probably paying attention.
I would think so. I'd hope so.
Yes. Susan?
Just one comment. I feel like if he did it once and then he did it 2 more times, he's thinking, well, I got away with it, so this is really not that hard. So I think we need to take that as an aggravation. So anyway.
Yeah, I was going to answer Kathy. The only clue is it says that the city was in the process of reviewing the project that was coordinated by the respondent. And so I took it as this person was either might have been a general contractor or some kind of project or construction manager, one or the other. But it was it sounded like it was in the kind of post-bid phase because with the revisions being made.
You've heard the case, Frank.
Yeah, this is my opinion, but I believe this guy knew what he was doing and knew what he was doing was wrong, and he did it anyway. And so I would like to move that we authorize a civil penalty of $5,000 for each of the 5 violations that occurred, and to take and pass them. Well, this person is not registered. Is that my understanding?
Right.
So I guess it makes sense to take and pass the rules. Anyway, that's my motion.
Your motion is 5,000 for each violation, or 5,000 total?
1,000 per each violation, 5,000 total.
Thank you. We have a motion on the floor. Kathy?
I'm just wondering if standard process is a letter that goes with that. Can we make it a cease and desist letter? So if he ever does it again and comes back, we have something else.
Cease and desist is in the consent order.
It is in there.
The language is in the consent order.
Okay.
Second. We have a motion and a second. Any further discussion? All in favor?
Aye.
Opposed?
Aye.
Thank you.
Is there no roll call needed just because Robert his accent just identifies him so clearly? Is that,
Yes.
I agree with that. Thanks, Robert.
No worries.
And number 3, 2019-078-691. The complainant took occupancy of his home sometime around the end of March 2015. The house began to experience settlement issues at a number of locations. The respondent was not the engineer of record, the EOR, but responded to a request from the home builder to provide an inspection of the home and evaluate the possible warranty issue approximately 3 years after construction of the home. The respondent assigned the inspection to a PE from his office, not an SE, who visited the home site on March 30th, 2018. The engineer for the respondent prepared a report based on, quote, limited visual condition survey of the interior floors, as well as limited observations of the framing within the crawl space, end quote. The report provided conclusions as to the cause of the failures, as well as recommendations for failure and remedies of the failures. The respondent responded to a second request from the home builder in August 2018 to provide a follow-up inspection of the home to evaluate the repairs recommended by the respondent's firm following their first site inspection. The respondent assigned the inspection to a different PE from his office, but also an SE, who visited the home site on August 24, 2018. The report noted deficiencies that were not adequately addressed from the recommendations of the respondent's first report, with additional repair instructions. Again, the respondent appears not to have had the actual plans for the framing and foundation requirements established by the EOR. The respondent responded to a third request from the home builder in September of 2018 to provide a follow-up inspection of the home to evaluate the repairs recommended by the respondent's firm following their second site inspection. This time, the respondent's owner visited the site on September 25, 2018, and was provided, apparently for the first time, a copy of the EOR's structural framing plans. According to the site visit memorandum prepared by the respondent's owner, which was sealed with the inappropriate date, upon review of the EOR's structural framing plans, the respondent noted that the home, as constructed, had an added optional loft with bedroom at the second floor level, as well as accompanying set of stairs. He also discovered that as a part of the option for including a loft, the EOR had designed a different framing plan that was not picked up by the framer, the builder, or the home inspector. There were joists and LVL material and a critical support beam missing from the construction. The respondent's report also included recommendations for modifications to aid in the compliance with the EOR's original structural framing recommendations. The respondent's owner made a final site visit on October 4, 2018 to inspect the work performed by the structural rehabilitation firm hired by the home builder to ensure they met the intent of the recommendations made by the respondent. The final assessment was that, in respondent's professional opinion, the house was, at the time, structurally sound. The complainant has not engaged the services of his own licensed professional to review the work performed, nor noted there is any continued damage following the final structural rehabilitation work performed in October 2018. Without any evidence that the recommendations made by the respondent have resulted in continued failure, it appears that the final recommendation made by the respondent has in fact solved the issue. It's reviewed by Board Member Alton Heathcote. Mitigating factors, issue has been resolved. Aggravating factors, failure to obtain the EOR's framing plans for the first inspection. Recommendation is issue a letter of caution to the respondent advising that an engineer has a duty and responsibility to obtain all information prior to performing an inspection on a project.
Thank you. Alton, anything additional to add to this report?
Yeah, thank you. Hello, 1, 2, 3.
Hit the
I'm offline.
speak. Hit the speak.
Oh, I'm on mute. I should be on mute anyway. I'll try it. There we go. Thank you. Thank you for that tutorial. If I were reviewing an issue, particularly a structural issue, I'd want the set of plans before I went out to review it. The first and second review, I'm not sure, and there was no information provided as to whether or not they even requested a set of plans. There was some intimation that they had, but they were told that maybe the plans weren't available, or they were given the wrong set of plans. The model of this home, and it's was constructed by a home builder that all of us have heard of. They build hundreds and hundreds of homes a year. It was a standard footprint, except in this particular case, what they all failed to know, including the contractor, the framer, and as I noted in here, and I apologize for the epistle, that's a really long explanation, but they all failed to notice that the homeowner had opted for this additive alternative where he could add a second floor to the home. And so they failed to, the home builder failed to structurally secure the foundation and the support for that second floor. They just missed it. Again, the first visit, the engineer who visited the site didn't have the plans. These are 3 years after the home was built. And if you saw the pictures, it was patently obvious that there were significant settlement-related issues. So the first individual, the first PE who went to the site didn't have the plans from the engineer of record. The second engineer, who's an SE, who visited the site, didn't have the plans. The third engineer, I'm not sure how he got them, but acquired the plans from the home builder, and there were specific notes from the EOR about the additional bracing and supports that would be necessary for this. All through the process, they were making recommendations on, they identified the problem, they made recommendations for improvements. The first engineer's recommendations weren't sufficient enough to mitigate the continued settling. The second engineer's recommendations got close, but in two particular areas still weren't enough to mitigate the continued settling. And when the third engineer went out with the engineer of records plans, he noted what the recommendations were. Once they implemented those recommendations along with in addition to the engineer of records recommendations, they made some additional recommendations too. The home building company, all through the process, 3 years after the home was built, continued to implement what this engineering firm had recommended. They finally remedied the problem. Apparently, there's been no additional settling issues. The complainant appears to be satisfied with the work that's been done, has beneficial use of his house. Other than the fact that they failed to acquire the revised drawings with that option in it, you know, they've tried to do their due diligence. The engineering firm that responded has tried to do their due diligence in the process. They've made recommendations and continued to go and visit the site and make additional recommendations. Should there, I would accept an amendment if somebody feels strongly enough about it, but given the fact that they continued to try to help and it ultimately evolved into a remedy that satisfied the complainant, I'd recommended the letter of caution with the notation in it.
Thank you. Ricky?
Thanks, Alan. I think it's key to know whether they asked the first 2 times for sets of plans and what they were told, because we constantly ask for plans and almost never get it the first time. Most of the time we have to end up burrowing through somebody's storage room to find plans because the answer is always no, there aren't any plans. But if they were told no, if they asked for them and they didn't appear until the 3rd time, I don't know that they've done anything wrong, because there are some things you just cannot see without plans unless you have destructive investigation. So you just have to kind of do the best you can. It may be an iterative step to solve a problem if you don't have the plan. So I think that's a key question. The other question I had is the respondent a PE, or was he or she just sending a PE?
The respondent is a PE.
Okay.
And an SE.
Okay.
And again, I agree with you. That was critical to this decision also. The implication was that they had requested plans, but the plans that they had for the house weren't the amended plans with that additional option provided. So they were just looking at the framing plans, not the house plans themselves. I've been in that same situation that you were discussing, where you ask for, quote, as-built drawings or any plans related to existing information, and I know and I agree how difficult it is to obtain those. As an added piece of information, when they finally did get the plans from the original engineer of record, apparently it was a very small note in a relatively obscure location where they actually found that modification to the framing plan. So again, thus the reason I felt like they had at least attempted to find those plans or get those plans, and that's why I didn't feel like it warranted or merited any sort of a fine or penalty.
Thank you. Frank?
2 or 3 things. One, it seems odd that the respondent is a firm rather than an individual, but that appears to be the case here. There are multiple people in a firm that are the respondent, I guess. The question is, there is an engineer of record. I'm assuming he had no involvement in any of this?
No, sir. He is remote.
Okay.
This company is an international company. The home building company is an international company. The engineer of record is an employee or a subconsultant to this home building company.
Yeah.
The other odd thing to me is, and I just was reading here that the contract, the builder, and nobody seemed to know anything about the revisions except they built this thing. Now, how'd they build it? From what? I mean, how do you add a story and a bedroom and with not having anything to build it by?
I think in typical fashion, and you're familiar with some of the way the home builders work, they have crews that come in. They have a foundation crew, they have a framing crew, they have a drywall crew, an insulation crew, a plumbing crew, and they're all done in these sequences. My notion is, there's no evidence to this, but I've seen this type of work performed a lot. My notion is that the individuals that built the framing were given the framing plans. That's it.
The incorrect framing plan?
The framing plans without the additive alternate for that second floor bedroom, and it's actually had a little sitting area also. One of the keys to me would have been, hey, why does a single story house need a set of stairs? The stairs didn't show up on the framing plan for the original construction. But then when the interior build-out people came in, they I suppose, assumed that the framing plan was correct, and they built the stairs in the second level.
Yeah, I've been drugged to see a few failing homes in the past, and usually it's there are no plans. The framer just built something that the lumberyard gave him to put together. This sounds like somebody is a little more on top of things if it's a large firm doing this, and having beams that aren't capable of supporting. You were talking about settlement. That sounds like foundation settlement, but it's just from what I'm reading through here, it sounds like you've probably got some sagging structure.
There were inadequate structural elements, and there are also an insufficient number of footing supports.
But it's a danger to the homeowner. However, we're looking at the respondent, and I'm not sure in the long run that what you're,
Who came in 3 years after the home was built with no access to plans. As far as they knew, the plans were for a two-story building.
Right. They were just checking and doing an inspection.
Correct.
They kind of
figuring out what was causing the problem.
Sounds like on the front end they didn't do a good job. They sent some guy out there and he looked around and said, "Yeah, you got a problem." It sounds like. But eventually they did solve the problem, so I think I'm agreeing with your recommendation.
Brian?
Actually, I guess after I list all this, I'm not sure they should have anything, honestly, because they looked at what they had and they came up. I read, well, you read, but earlier about they said this is based on a visual inspection, so they weren't given drawings, and then finally at the end they were. So I'm not even sure they need a letter of caution, because I'm sure once they got the information, they did it. So like Ricky said, we don't know if they asked for, if they just forgot to ask for plans, but I kind of believe that we wouldn't go out. No one would go out there. That's almost like the first thing you want to know is, well, let me see plans and get started with it. So anyway, I'm not sure they need anything, honestly, because they did fix it once they saw it. It was probably obvious to everybody. The building company really should, and I know we have no, ability to do anything to them, but they're the ones that should have more an issue with this. So anyway, I don't think my recommendation would be anything to the respondent.
I think the reason I recommended that is they agreed to take this job and they performed the services without having the plans. Ordinarily, I think I would hope in a similar situation, if I didn't have the plans to review to determine structural viability, I'd have said, guys, I don't have enough information. I can't do this.
I agree with Brian.
This is Robert. I'm going to agree with Brian. I think that they may have even asked, and we've all have done home inspections like this where you go out and you see something sagging, and my first inclination is it's always water or something, or somebody didn't. Because an LVL beam, if I'm not mistaken, is generally an internal. Couldn't see anyway, right? It's sheetrocked over, and unless it's something in the footing or under the crawl space.
This was actually part of the floor support framing, Robert.
Okay, but still, it's those are hard to see sometimes. But I understand that if it's not there and you ask for plans or tried to get plans, you assume that the building looked at the building, have said, done a framing inspection, out. It wasn't have an LVL beam in it. I would assume that in order to pass the framing inspection, it had to be built by the. Sometimes we all chase different things, and we've asked for information, and it's just not all there. So I kind of agree with Brian on this.
Thanks, Robert. Ricky?
No worries.
I agree with Brian and Robert that it seems like a reasonable course that if they asked for plans, didn't get them, that they wouldn't refuse to go out there because it's possible. You never know until you see it. It's possible it may be totally obvious what the problem is, but it sometimes, again, is just an iterative process, and I would not think a letter of caution is really. I couldn't agree with that in this case because the way I understand it, letter of caution is like a ding in somebody's record, and I don't know that these people should be dinged for what might have been good service.
Kathy?
Yeah, I'm in agreements with Brian. It seems like if we knew for a fact that they asked for the original design drawings and they received them and they failed to review them, then that would, I think, constitute something that is outside the standard of care. But we don't know what they asked for, and residential home building claims are always difficult because the informality of a homeowner versus a business client who you may have better records or may understand the questions easier. So unless we knew, and if we knew that they had committed something that was, less than standard of care, but in this case, I don't think we really know that for a fact. I think we might just be assuming that he, quote unquote, should have done a better job. So,
Steve?
I was just wondering if the complainant filed a complaint with the Contractors Board.
I don't have any information on that. I don't know if Stuart does or not.
I don't either.
It seems that might have been an appropriate thing. And the other thing I wanted to was the building permit issued from an entity that requires detailed plans. Some municipalities and counties, you can get a permit for a house pretty much just on an application with no details.
My assumption was based on who the home builder was. They don't build in rural areas. They're pretty much urban area builders. That doesn't mean that this wasn't in a rural area, but that would be extraordinarily unusual.
So do you know, was it in a urbanized area? You know the location. I mean, I guess you can't disclose it, but you probably know.
I don't.
You don't? Okay.
Mr. Chairman, I make a motion that we take no action and we close the matter.
Okay, we have a motion on the floor.
I'll second that.
We have a motion and a second. Any further discussion? All in favor?
Aye.
Opposed? Thank you. Motion passes.
Number 4,
Alton.
2019-077-261. An anonymous complaint was received questioning the licensure of respondent after respondent had pled guilty of a felony for hacking into former employee's computer system in 2017. There are no allegations of wrongful conduct or performance issues associated with this complaint. On August 15, 2017, respondent executed a consent order with this board allowing the voluntary revocation of his professional engineering license. On January 1, 2019, respondent reapplied for a professional engineering license in accordance with the board's rules and regulations. On April 3, 2019, respondent met with the engineer committee of the board, explained the circumstances related to the guilty plea, sentencing, and restitution. Thereafter, the engineer committee unanimously recommended to the board that respondent be reinstated. As a result, on April 4, 2019, this board unanimously agreed to reinstate respondent's license. This was not reviewed by a board member. The mitigating factors are no allegations. Board has previously reinstated registrant. Recommendation, the board has previously heard and decided this matter close.
Thank you. Any questions for Stuart?
I make a motion to approve the recommendation.
A second.
We have a motion and a second. Any further discussion? All in favor?
Aye.
Opposed? Ayes have it. Thank you.
Number 5, 2019-082-701. Respondent self-reported of practicing on an expired license. Respondent stated work was performed on 2 projects after the license expired on January 31, 2019. Respondent has submitted the application for renewal on August 27, 2019. Respondent is an employee of an electrical cooperative and therefore exempt. Reviewed by board member Stephen King. Mitigating factors self-reported. Co-op employee exempt. Recommendation is to close.
Thank you. Steve, any additional comments?
No, I'm happy to respond to questions. I think Stuart covered it.
Thank you. Chair will entertain a motion.
I make the motion that we accept council's recommendation to close the case.
A motion and a second. Any further discussion? All in favor?
Aye.
Opposed? Motion passes.
Number 6, 2019-078-821. Respondent failed to comply with a PDH audit in a timely manner. Respondent states that the email notices went to a former employer's email in which respondent left just prior to the audit notice being sent. Respondent did receive the complaint notice at the street address on file on September 23, 2019. The PDH audit notice was also sent to the same street address. Respondent admits it is his responsibility to update the board. Respondent submitted the requested PDH audit materials on October 8, 2019 and is compliant. Reviewed by board member Stephen King. Mitigating factors, compliant during PDH audit period. Non-response was not willful. Aggravating factors, failure to notify the board change of employment and contact. Recommendation is a letter of caution concerning the importance of notifying the board of any change in contact information and pass the laws and rules exam.
Thank you. Steve, any additional comments? Thank you. We have a recommendation in front of us. We'll entertain a motion.
So moved.
Robert?
Second.
Motion and, okay, Kathy is the second. Any further discussion? All in favor?
Aye.
Opposed? Motion passes.
Number 7, 2019-076-941. The complainant hired contractors to construct a warehouse building. Complainant alleges the trusses were not properly stored and were exposed to moisture for an extended period of time of 3 months. According to the complainant, when the trusses were installed, they were bowing, and the contractor altered the trusses by nailing 2x6s in order to decrease the bow. Complainant alleges the alterations and extended exposure has caused the warehouse to be structurally compromised. Complainant further alleges the staples were coming out, mold in the building, screws ripping out of the eaves, gutters ripping loose, and doors not operating properly. Complainant is a named defendant in a current civil lawsuit. As part of complainant's defense, complainant has sued the trust company as a third-party defendant. Respondent was retained by the trust company to provide expert testimony and consulting services for the lawsuit. Respondent provided an affidavit in the litigation identifying opinions reached as part of engineering investigation. The scope of the assignment was requested was to evaluate the trusses in the current as-built condition as of the date the trusses were inspected to determine if the trusses were structurally compromised. Respondent's report concluded the trusses were not structurally compromised, the storage of the trusses had no adverse effect, the bowing were localized to the bracing itself, and water stains on the trusses were due to past or current leaks from the roof after installation. Respondent states that all other allegations made by complainant involving storage of the trusses, staples, mold, screws ripping, and gutters coming loose were beyond the scope of the assignment or not associated with the trusses themselves. After a preliminary review, it is recommended to wait until the civil litigation has been resolved before a formal and detailed review is made. Reviewed by Board Member Alton Heathcote. Recommendation, place in litigation monitoring.
Thank you. Alton, anything additional?
No.
Thank you. We have a recommendation made. Ricky?
One question to Alton. This sounds like something more for a contractor's board, or not so much our board, unless there's something here I'm missing in terms of a registrant's role in this.
There is. The complaint was filed against, the respondent in this case was the individual who went out and did the post-construction review and made gave his findings. And based on the information that I saw, I would agree with the complainant.
Thank you.
Ms. Robert, I agree with your recommendation to wait. This sounds to me like our kind of situation that recommendation sounds a little goofy to me. So, but I agree with your recommendation to wait till litigation's been taken care of.
Thank you, Robert. We have a recommendation before us. We'll entertain a motion.
I'll make a motion to accept the recommendation.
We have a motion.
Second.
Motion and a second. Any further discussion? All in favor?
Aye.
Opposed? Ayes have it. Thank you.
Number 8, 2019-080-371. Complainant and neighbor have been involved in a property boundary dispute for years. The neighbor hired a contractor who worked with respondent to build a gravel drive next to the complainant's drive. Complainant alleges the contractor and respondent breached their property with heavy equipment while constructing the gravel drive, damaging complainant's property. The basis of the complaint is directed towards the contractor. The respondent was hired to supply services in facilitating the property acquisition, including drawings stamped by a licensed surveyor. The court has rendered an opinion concerning the damages to complainant's property. The court has also decided access disputes between the parties. There is no evidence that respondent caused the damage to property or endangered the health, safety, or welfare of the public. Reviewed by Board Member Alton Heathcote. Recommendation is to close.
Thank you, Alton. Any additional comments?
Yeah, just a few. This was, I think there was some lingering issue with the person that filed the complaint with the complainant, that this individual who purchased the property next to them was going to build a house, and this respondent was building a driveway, as part of the operation, part of the construction process for building the driveway. The respondent is also a PE. in the process of building this driveway, may have gotten over towards her property a little bit and temporarily made access to a horse barn a little more challenging. That was remedied right away. I mean, there were some verbal altercations, but other than that, there was really no damage to property. There was, while somewhat limited, there was always accessibility. It was typical construction, typical things that occur during a construction process, and again, no potential threat to the public health, safety, or welfare. And again, we have a judge rendering that opinion.
Thank you. We have a recommendation before us. We'll entertain a motion.
So moved.
We have a motion.
Second.
Motion and a second. Any further discussion? All in favor?
Aye.
Opposed? Ayes have it.
Number 9, 2019-085-421. Respondent self-reported work performed on numerous projects while on an expired license. Respondent's license expired on January 31st, 2018, and respondent did not realize it was expired until September 17, 2019. Respondent remained employed with the current employee performing work that did not require a license, such as drafting paperwork, and working under the direction of a licensed engineer. Between January 31st, 2018 and September 17, 2019, respondent performed work on 34 projects, which included design and layout, grading, drainage, water, and sewer. Respondent also states that a majority of the work received a secondary review by a licensed engineer with employer. Respondent has applied for renewal on October 16, 2019. Reviewed by board member Ricky Bursai. Mitigating factors self-reported. Recommendation, authorize a civil penalty in the amount of $500 for practicing on an expired license and pass the laws and rules exam to be settled informally by consent order with authority to proceed to a contested case proceeding if the respondent does not agree to the informal settlement.
Thank you. Ricky, any additional comments?
No, unless somebody has questions.
We have a recommendation before us.
I need some clarity. So the engineer worked on 30, how many projects? 34 projects, but he did not seal any of these projects.
He did seal.
How many did he seal?
I think all of those.
34 projects. He sealed 34 projects.
Right.
Okay, so $500 for 34 projects? Really?
Yeah,
I have a problem with that.
Yeah, when I reviewed this, I didn't give Stewart a dollar number recommendation because I think this is an issue that we have not decided. I don't think the $500 matches what we've done in the past, but I also, if you looked at it per project, it'd be like $17,000 fine, which seems excessive too. These are for 34 jobs, it had to be, these are maybe 1 or 2 sheet jobs is in my mind. I don't know how different that is than somebody who works on one huge job and does 200 sheets. That would be a $500 fine if we did it by project. But I think we've got to decide how we're going to look at this issue of license that have expired, working on expired license. We approved in case number 2 today, somebody had worked on 3 projects, and we approved a $500 fine on that. So I agree with you, Rick. I don't think the 500 matches what we've done in the past, but I don't think we have decided how to do this, whether it's by a year or months or whatever. What Stewart is suggesting is that this is one offense. It's working on an expired license legally. So,
this is Robert Campbell. Rick, I agree with you. And I know, Ricky, we did that on that one before, and I probably should have spoken then a little bit more. but it says each separate violation. And I mean, I take that to mean that every time you stamp it and you're not registered, that's a violation. Now, we can argue about sheets or projects. I tend to think projects are probably the right way to do that, just because, you know, regardless if you stamp one sheet, have a set that's one sheet or 200 sheets, each one of those projects can impact the health, safety, and welfare equally. But I think 34 projects is a significant amount that you should have known something in that period of time. So I tend to think it's 34 times 500. So it says each separate violation.
May I ask, historically in the past, we have calculated 500 per each violation, correct?
It kind of depends on what you call a violation. I mean, whether that's by job, by sheet, or the way Stuart was looking at it, by the fact that it's just unlicensed activity. But I think it's been by job in the past, by project.
We've done it, this is Robert again, we've done it by job, and remember, we got the pushback because from a legislator for sunset hearings. That's when we started kind of, well, I don't know. So, I mean, we've done it that way in the past. We reduced that other person because of mitigating circumstances. If you remember, they had a severe illness stuff that they really didn't let us know about in the beginning. They would have told us that in the beginning. That penalty would have probably been, we would have probably come to the same conclusion we did after the fact. But I think it needs to be per instance, per separate violation is what it says. And I mean, I don't know, you know, exactly how but separate violation seems to me 34 times 500.
Thank you, Susan.
As I stated at our last board meeting, we need to be consistent. They're going to come back and, you know, slap us on the hand if we're not consistent, and whether we need to change it and make it so that it's a reasonable, you know, penalty per project. If that's the case, we've got to do something consistent because it's going to nullify what we are here for. That's my comment.
Kathy?
Well, I totally agree with the consistency. I ask that question a lot in terms of what have we done in the past? What have we done in the past? What have we done in the past? And so I'm sorry I wasn't vocal on this on project number one, but part of me kind of likes to defer to the attorney recommendation and the person who reviewed it. And so project number one, if we go back and we're consistent, it says respondent listed 5 projects that he stamped, 5 projects that he stamped while his license was expired. However, we had a $500 recommendation, and Stephen, you reviewed it, and Stephen gave it a thumbs up. And so I think that's, you know, we're all kind of first project out of the chute, and we're moving on, and we approved it. But we do need to be consistent. I just think that is just a recipe for disaster going forward. So if it's, and I do think that it's per project. I don't think it's per sheet, because the violation, if you are stamping 20 sheets or 200 sheets or 1 sheet, mentally you are stamping and you are everything that's there. And I think that constitutes a violation. So I would be in favor of going back to project number one and revisiting that if that's possible, and suggesting a $2,500 fine for the 5 projects which constitute 5 violations. And then if we're going to be consistent, then it's 34 times 500, and he can appeal it, and he can come in and he can say whatever the mitigating factors are that we should take under consideration, because that's how the process is set up to work. But for us to assume mitigating factors on his behalf and say, well, you know, 34 projects, they probably weren't that big of a deal. And I think that we're just making a big assumption on things, that we should wait and hear the facts. And if I got a notice from the board and it said 34 times 500, I'd be down here by the end of the day. So trying to figure out what I did wrong and how to make amends. And I'm going to give the benefit of the doubt to the respondent and think that they'll do the same thing. And if he has mitigating factors, or if he has something else to share with us. But for us to give him a $500 pass, I could hardly live with myself if we did that. That just seems wrong. So, again, let's be consistent. Let's agree on what constitutes a violation. If we need to have that conversation so we all remember it going forward, let's do that. And let's ask council to help us remember what those decisions are from the past and be consistent in your recommendations back to us, unless you know a reason why it should be something different, in which case we absolutely want to hear that. But if you will give us in the future recommendations that are consistent with what you know the board has done in the past, and you can comment on that any way you want, then I think that would be really helpful, because I certainly have a tendency to defer, and I don't want to defer in error. So let's all do this together, and I'll shut up. Thanks.
Thank you, Brian.
I just wanted to say that, it feels, only thing I'm curious about, sentences 3 and 4 with your information, Ricky, contradict each other, because it says in 3, respondent remained employed with the current employee performing work that did not require a license, such as drafting paperwork and working under the direction of a licensed engineer. But then, according to what you're saying, he stamped 34 drawings. Those two things don't add up. One thing he's saying, he did not do it. He was just drafting and working under the supervision. But then what you're saying is the fourth sentence is saying, no, he actually stamped the drawings.
Right, good question. I believe that the respondent didn't, while he didn't know that his license had expired, stamped 34 projects. The minute he found out his license had expired, he stopped being the person that stamped and became a support person for another registered designer.
Okay, we've had a lot of discussion. Rick?
Okay, that cleared that up for me as well. But are you making a motion, Kathy, that we go back and amend one of the previous cases to reflect the $500 per violation? So when we go in, and is that a separate motion, or is that part of this motion where we assess a penalty for $500 per incident? I'm just trying to
answer that question for me.
All right, thank you.
To that, I don't think there's a comparison. I mean, the one you're talking about, this guy fraudulently affixed that somebody else's seal.
It's project number. It's case number 1, not case number 2. It's case number 1.
Oh, okay.
Case number 1.
The other thing is, 500,000 to 1,000 is the recommended penalty, and so depending on the case, it can be 1,000 if we thought. So 500, from what I read, is kind of the minimum per violation. The other thing is, I think there's kind of to me, an aggravating factor in this, in that when somebody forgets to have their license renewed, if it goes a year and a half, that ought to be kind of a clue you didn't renew your license, especially if you're a licensed professional. And I don't see anything in here that says why they might not have decided or thought they might check and see. But to me, if it goes on that long, you kind of know you hadn't renewed your license.
You would think. I agree with you. And I would say, again, that's something that he could present to us if he wants to appeal the decision. And,
right.
I think this board has shown compassion for people who've had truly health-related and family-related emergencies, and we'll listen to what anybody has to say. And maybe that's a great explanation that he can give us. It helps us better understand why he shouldn't receive the maximum level. But the maximum level, the minimum level I think the minimum level is the 500 per violation, and the violation times 34. That's what it looks like to me. Now, if we want to debate what a violation is, that's fine. And going back to Rick's question about making a motion, I have no idea. I have no idea where we are in the process, but I'm happy to do so, and I'm happy to reopen case number 1 if that's the appropriate thing to do.
It seems to me that we're really talking 3 different things. One, the possibility of going back and looking at case number one again. Secondly, defining what a violation is, making a statement, or us as a group deciding what a violation is. And then I guess the third is the amount, which we're saying is the minimum of $500, the maximum of $1,000. So that's already on record, correct? And then obviously getting back to item number 9, which we have not yet made a motion nor made a decision on. So if we make Ricky?
No, go ahead.
I was going to say, if we can suspend the discussion of this item number 9 for a moment, and if we can clarify what we as a board believe a violation is. A violation, from what I hear around the table, is a violation is a set of drawings. When you stamp a set of drawings, that's one violation. Whether that's 6 drawings, 2 drawings, 200 drawings, that is one violation. That's what I hear.
I'd like to make a motion that we table discussion on item number 9.
Don't table it, you have to vote it back in, but whatever.
Can I ask one question regarding that, though? Why can't we just settle it all? This is going to be our violations, and we decided on 9 and decide it going forward, and then if we can, reopen 1. Then we go back to 1. Why do we have to suspend this one and come back to this one again? Can't we just make a decision based off what we're talking about now?
I suppose we can. My thought was, let's make a statement as a group, a singular statement that this is what a violation is in our view, and then we would use that
to
in the years to come.
And then we go back and do 1. I guess that's what I'm saying, instead of going back again. Let's
Susan?
just finish 9 now, since we're opened it.
Going back to the book, and Ricky's been so much better than this than I. But one of the statements here, under civil penalty guidelines, each day of continued violation may constitute a separate violation. So to me, we're justified if there are 34 acts of violations, then that each one of those will receive a penalty. We could even make it even harder per day, you know. And again, I go back to we need to be consistent, and I think our guidelines are here. We just need to make sure that we're applying them appropriately. And I think, again, go back to being consistent. We need to go back to case 1 and make it times 5 and look at case 9, you know, as a separate scenario as it is. So that's my thought.
Thank you, Frank.
Mr. Chairman, I would like to move that we authorize a civil penalty an amount of $500 per project sealed. In this case, that would be $17,000 for practicing on an expired license and passing the laws and rules exam.
Thank you. We have a motion.
Second.
And a second. Any further discussion? All in favor?
Aye.
Opposed? Thank you. Motion passes. Mr. Thompson.
Mr. Chairman, I would like to make a motion that we reopen case number 1 and reconsider our civil penalty for the amount of projects that were sealed by the engineer.
And it's a motion.
Second.
We have a motion and a second. All in favor?
Aye.
Opposed? Okay. We are now back at item number 1 on the agenda, which is item number 2.
Sorry.
Item
Number 1.
Number 1, I'm sorry.
Item number 1.
I apologize.
And that item number is 201-907-3421.
Mr. Chairman, I'd like to make a motion that we amend our previous vote and that we institute a fine of $2,500 reflecting 5 violations.
A second.
We have a motion and a second. Any further discussion?
And that includes passing the laws and rules exam.
Correct.
We have a motion and a second. Any further discussion? Steve?
But just for clarity, this individual did submit the work that he did. So I thought I ought to tell you. That I don't know that I'm not arguing to modify it, but I just thought we ought to know. The respondent stamped a right-of-way revision sheet for a looks like a interstate interchange project. He stamped a industrial access construction plans that had not been bid yet. He stamped a state route right-of-way plans. He stamped another set of construction plans for a state route that had not been bid yet. And he stamped an additional set of construction plans for a state route.
Thank you.
So, to my understanding, he stamped 4 state-related right-of-way plans, which are definitely representing the health, safety, and welfare of the residents of this state. Am I correct? Regardless of whether they were bid or not, he did stamp those plans. All right, thank you.
But 2 of them were right-of-way plans.
But 4 of the 5 violations were state-related, transportation, TDOT, or
they were all roads. One of them was a state industrial access funded project.
Oh,
so
okay,
that,
so
that
5 violations.
Could have been a state route. It could not have been state.
Okay, thank you.
Probably wasn't, but right.
I think given that statement, that with the penalty of if the registrant would like to come before us and discuss that, then that would be their decision. Thank you.
Thank you. I believe we have a motion on the floor and a second. Any further discussion? And please remind me of the motion again.
The motion was to dispense with our prior vote on item number 1 of the legal report. And the new motion was to authorize a civil penalty in the amount of $2,500 for practicing on an expired license relative to 5 violations, and to pass the laws and rules exam.
Thank you.
And I seconded.
We have a motion and a second. Any further discussion? All in favor?
Aye.
Opposed? Ayes have it. Thank you. Now let's resume and move back to item number 10, I believe.
Number 10, 2019-082-301. Complainant hired respondent to design a garage and bathroom/closet addition and paid respondent $8,125 for time and completed drawings. After several plans and revisions, complainant alleges that it was apparent that the roofing and structural aspect of the project was beyond respondent's experience and knowledge. Complainant's contractor allegedly advised complainant to hire an architect as the contractor believed the respondent did not have the competency for this project. Complainants hired an architect with 40-plus years of experience. This architect requested as-built drawings from respondent. However, respondent requested the architect to sign a waiver for release. Complainant felt respondent should have released the drawings since they had already paid for them. It was the opinion of the architect that the drawings were completely unusable. Respondent states they were the only designer on this project, and complainant was fully aware that respondent was not an architect. Towards the end of the schematic design phase, complainant walked respondent out into the backyard and instructed on how the roof was to be drawn. Respondent informed complainant that the suggestion was not an industry standard detail to create a large flat rubber membrane at the top of an existing pitched roof in order to maintain the same existing aesthetic from the ground view. Respondent felt it would be problematic, and if complainant wanted to pursue that idea further, it would be better for the parties to end the relationship. Respondent received an email from an architect requesting the drawings. Respondent requested the architect to sign a waiver due to sharing CAD files, which are industry standard. Respondent believes the letter that was received from the architect claiming that the drawings were unusable was retaliation and anger for signing the waiver. Respondent claims to have never issued a set of drawings that did not get approved for building permits. The drawings were also reviewed by a licensed architect and licensed contractor and deemed 100% constructible. The proof does not support the competency allegations that rise to the threat of the public health, safety, and welfare. Further, the project was on a residential home less than 3 stories in height and less than 5,000 square feet in total gross area. As such, the project is exempt. Reviewed by Board Member Brian Tibbs, mitigating factors is project exempt. Recommendation is to close.
Thank you. Brian, any further?
After I did the whole thing, I felt like I had done an ARE question, because I read everything, and it felt like, but the last paragraph seemed like it's the one that I went with. At the end, it was a residential home, so it would actually not fall under our purview anyway. And it seems like the interior designer always expressed that they were not an architect, and so that's why I felt like it should be closed based on that. But
Thank you. We have a recommendation for us. Susan?
Well, I disagree. I don't feel like, based on rule number 0120-4.10, that a registered interior designer providing services specified by law to require other licensed professionals. Structural, components should not have been done, in my opinion, and that's, I don't disagree with what he's saying, but I feel like there's more to it. And with this whole thing of interior architecture, flaring up, I don't want us to be lenient with the health, safety, and welfare of the public. So,
Thank you. Recommendation before us. Frank?
Question, just to be sure, Brian, the complaint here is the complainant is saying that the respondent is incompetent. Is that the complaint?
that's what it seemed like it was saying. But later on, said that the drawings were also reviewed by a licensed architect and licensed contractor and deemed 100% constructible. So it seemed like it was one person's word against another person's word. And, like I said, since anybody, unfortunately the way our law is, anybody registered or just a drafter, anyone can do this type of work. It seemed like it wasn't, it didn't fall into that. But anyway, that's what I understood.
Susan?
Do we have this in writing from the licensed architect and contractor? They said it was constructible.
Did we have that?
Do we have anything in writing from them?
I believe there is something in writing from the architect and the contractor stating it was constructible, and respondent reached out to them to make sure, to verify.
But we don't have a copy of it.
I'll have to look and see.
Okay.
Ricky?
And I agree with what Brian said. Per our laws and rules, anybody could do the design for this structure. So it kind of comes down to, Brian, do you feel like the service this person offered? I do feel like, however, even if it's something that doesn't meet that, if the respondent was working outside their area of expertise, where it would badly affect somebody, that could still be an offense. But in this case, their service may have been understood just to do some design concepts that a contractor would take from there, which is absolutely within the law to do. Did you get a feel for that? But basically, for the service that they agreed to, were they operating outside their expertise area, or did what they provide seem appropriate?
And I didn't see drawings, I don't think, but I based on what I understood, it was typical what you said, that they, and I'm, because you didn't have drawings, I couldn't say it was just like incompetent, but because of how residential builders are able to build, a concept is a lot of times all they needed. And I didn't understand why they were upset about the waiver because, that's not uncommon that you do a CAD waiver, so that's
Exactly.
typical. So I don't know. It did seem a little, tit for tat a little, but that's just based on the information I have.
One part of this, I guess there were two architects involved that looked at the plans. It says that it was the opinion of the architect, the first one, I guess, that the drawings were completely unusable. Any ideas whether that meant they were done incorrectly or that he couldn't read the CAD drawings? Any ideas there?
Let me say one thing. We do have a letter from the licensed contractor and the licensed architect stating that the plans were 100% constructible.
That's the question I asked you a few minutes ago.
Right.
We've got it now. Okay.
Yeah.
All right.
That answered my question.
Yeah. One other point, whether or not a building falls under the requirement of requiring a licensed professional, it still has to be built by the building codes. Now that may be done by a contractor and or a house builder, but nevertheless, if this person has done drawings like structural drawings for a house, they need to be done right. That doesn't disallow you to do anything you want to do if it doesn't require a design professional.
No comment.
We have a recommendation before us. I'll entertain a motion.
I make a recommendation to accept the recommendation of council to close the case.
Motion to approve the recommendation. Second. And a second. Any further discussion? All in favor?
Aye.
Aye.
Opposed?
Nay.
For the record, we have one nay. Thank you. Next item.
Mr. Chairman, I would like to amend my vote to a no. Thank you.
We should do a roll call since I couldn't vote. So
I think there's 2 no's and the rest are ayes.
Yes.
1, 2, 3, 4. Okay.
Never mind. So we're okay, right? Okay. All right. Next item, please.
Number 11, 2019-089-381. Respondent has been licensed in Tennessee since 2001, working in private firms until 2011 when employed by a city street department. Respondent self-reported that licensure had expired in 2017 and that notification should have been received by the city accountant that pays the renewal fee. Respondent is unaware of what caused the administrative error but has submitted reapplication and provided PDH compliance. Respondent's duties include managing a team of field personnel, maintaining street signs, pavement markings, traffic signals, and street lights. Respondent states that no designs of any construction plans or stamp to certify any reports, documents, or plans has been performed after expiration. Respondent's reapplication is currently in process as of August 30, 2019. Reviewed by board member Alton Heathcote. Mitigating factors, self-reported, did not seal or perform design work. Recommendation is a letter of caution concerning renewal of license and pass the laws and rules exam.
Thanks, Alton.
Yeah, I'd like to add, there is one aggravating factor. Subsequent to the review of this, I reached out to several people that I know that are licensed engineers in public service, and each of them said that when their license renewal comes, it comes to them, not to a city accountant or a city attorney or a city manager. It comes to them. And therefore, I think, and again, this person had been employed by this city since 2011. Therefore, he'd been through other license renewals, and I think it's his responsibility. So I would enter that as an aggravating factor.
Thank you. Further questions of council or Alton? Kathy?
The only thing I was going to suggest is that I think that this is a good exhibit in support of us having a discussion of what constitutes a violation, because practicing as an engineer isn't limited to ceiling drawings. And so, although it doesn't read that he did anything that would constitute practicing as an engineer in this paragraph of limited duties, I think it speaks to the issue that it's entirely possible that registrants are executing duties of a licensee above and beyond what would simply be stamping a drawing. So if we're going to have that discussion, I think we need to take that into account. But under here, it doesn't, you don't get the impression he was doing anything that constitutes practice. Okay, thank you.
I think most of his work was maintenance.
Supervisory duties. Okay, thank you.
Thanks. We have a recommendation before us. We'll entertain a motion.
So moved.
We have a motion.
Second.
And a second. Any further discussion? All in favor?
Aye.
Opposed? Ayes have it. Motion passes. Next item.
Number 12, this was an informal conference, 2019-023-531. Complainant was filed against the respondent by the State Fire Marshal's Office for allegedly practicing outside of area of competence related to ceiling plans and drawings for a church. The respondent provided a response and stated he was has considerable experience, with similar projects. The respondent has experience in design and shift support for nuclear power plants for 20 years, and it was routine for the respondent to interpret and revise structural, electrical, mechanical, and HVAC drawings. The respondent has been a structural engineer of record for shopping center upgrades, large apartment buildings, and various other projects. The respondent stated that the drawings that were sealed for this project were for building exterior elevations, basic floor and equipment plans, electrical panels, and legend drawings. The respondent is familiar with design output, and an electrical contractor has looked over the distribution drawings. After review, the contractor has found the drawings acceptable for construction, and the local engineering firm is satisfied by the level of detail. The respondent stated the original drawings were mistakenly submitted without a seal, and the project manager sent the wrong files. The project manager stated they would resubmit the correct set of drawings. This complaint was reviewed by Board Member Stephen King. Also, an informal conference was conducted by Board Member King with the respondent. Mitigating factors: no prior disciplinary action during a period of licensure in excess of 35 years. Informal conference with board member was held. Recommendation: letter of caution about practicing outside area of competence and experience. Board decision was deferred to December meeting. The new recommendation is letter of caution.
Thank you, Steve. Anything additional?
This was discussed at the last meeting, and I think it was, I don't remember which board member, but there was a concern about additional information, and I don't recall what that request was. I did have, I think the informal conference was in August, if I remember correctly. The end result was that this respondent decided to withdraw from the project. In the end, he felt like his firm, or it's pretty much a one-person firm, was too small to provide the level of detail of drawings that was required for the fire marshal.
Thank you. We have a recommendation before us. We'll entertain a motion.
Steve, this is Robert Campbell. Do you think the guy knew what they were doing? I mean, based on your conference, because like their former work.
I think he has experience in providing designs that are safe, but he didn't have experience in the level of detail that the fire marshal wanted to provide.
Ricky?
Yeah, I didn't see the set of plans, Steve, but reading the words that somebody's a structural engineer who's worked in a nuclear plant, I think it would be very surprising if they were able to keep up with how fast the codes are changing for HVAC and electrical design. Between outside air ventilation and energy codes that require things like daylighting controls and I mean, they are in the code. And if you have been designing churches kind of on the back of an envelope, you're not going to know that. And so I think it would be highly unusual for somebody that's described in here to really know what they're doing. And people think that churches are easy, and they're actually one of the more code-wise intensive because of the people occupancy. So I totally agree with a letter of caution and I think some good was done by this person dropping out of the project.
I agree, and I think it was good that he got out of this project.
Frank?
Yeah, two things. One, he's doing a church and submitting it to the fire marshal. That tells me that's a church of over 300 people. It's an assembly occupancy and totally different from a nuclear power plant or some of these other things mentioned. And like Rick said, the HVAC requirements are different for a church and for an assembly of a large group of people. The other thing that kind of seems strange to me is the last sentence or two where it says the original drawings were mistakenly submitted without a seal, and the project manager sent the wrong files. Who's the project manager?
I think he's referring to the contractor.
Well, okay. When having submitted a lot of drawings to the state fire marshal office, that's done through their portal, and you have to. I don't think the contractor would be doing that. That has to, and there's a lot of information that you have to include before you even download your drawings and so forth. That would say who the designer is and who the local fire department. There's a lot of information that goes when you make that submittal, and to kind of imply that somebody else did it seems a little strange to me. And the state fire marshal's office would immediately turn down something without a seal, and really not review it and say he's practicing outside of his area of competence.
I don't think we have any more detail about how that happened, whether it was attempted through the portal or not. But it was rejected without a seal, and then when the engineer resubmitted it, that's when the state fire marshal filed the complaint, because it was one of those situations where one registrant stamped all the sheets, like we've all seen in these complaints.
Yeah.
I think obviously willing to hear whatever the board's discretion is on this, but I think it was good to call the individual in for a conference, and that's one that I was given the opportunity to do by phone, but I thought it was important to come over here and look him in the face and deal with the issue, and I think we made a point with him that he needs to be careful about the kind of projects he gets involved in. But if you think you need to go further than a letter of caution, obviously that's up to the discretion of the board.
Alton?
I've got a couple of questions, Steve. Did he get paid for performing the work that he performed?
I don't recall that being in the information we got. Do you, Stuart?
I was not in the
Well, that's right. It was
conference.
Shalina.
It was Shalina.
Shalina was at the informal conference.
but-
I would assume that he got paid, but I don't think that was in the information.
I would assume so too, and he did put together a set of plans that had apparently electrical, HVAC, and other elements in it. And if he spent much of his career as a design for shift support for nuclear power plants, that doesn't necessarily imply that he has that level of competence in other places. And your recommendation about a letter of caution about practicing outside the area of competence. We've had cases like this before. I've reviewed cases like this before, and generally we've also assessed some sort of a penalty with that for the practice outside of competence, in addition to the letter of caution and requiring them to take and pass the laws and rules exam.
Sorry. Before we assume that he got paid, is it possible that he is a member of the church and that he was doing the work pro bono? I'm just asking.
I don't think we know that. I think what happened in this situation is that he had been doing work with this contractor. This contractor got the job with the church and came to him to help him get a permit.
Frank?
I do have one, and I think it's a good thing that you talk to this person. But he is a PE, which, I guess you could argue that he is licensed to do structural, electrical, mechanical, and HVAC. But the architectural part, we hadn't really talked about. When he decided that he was doing something he shouldn't be doing, and from what you described, what part of it did he think he wasn't capable of doing? Was it the architectural part, or was it some of the engineering part?
I think it was more the fact that he was probably more accustomed to working in a rural area that didn't require as much submittal, and when he realized the level of detail that was required, I don't know that it was ever confirmed that he backed out because he didn't think he had that level of expertise, or he didn't have the ability to produce that level of detail. Because in some rural areas, you can get a permit to build a structure with a minimal amount of engineering or architectural work, and he didn't come out and say this, but that's what I think that he was used to doing. And when he realized this was a different game, he backed out.
Alton?
Oh, I'm sorry, I left mine up.
Ricky?
I think when I looked at it, I've looked at these churches a lot. It common with that. The plans were obviously lacking from when the one person did everything. There was an incompetence, evidence of incompetence, and so a fine was assessed. But here, it said after review, the contractor found the drawings acceptable for construction. That doesn't tell me that much, because contractors can build from nothing. But it says a local engineering firm is satisfied by the level of detail. So I don't know whether I would be or not, but I'm just going on this. The local engineering firm satisfied with the level of detail made me satisfied with the letter of caution and not having a fine. But architecturally is another question. If an architect looked at the plans, would they be satisfied with the level of detail? I don't know.
Yeah, I know, and I've reviewed on this board a few churches where somebody stamped everything. They were trying to help the church out, basically. And from even an architect that was stamping all the other stuff, his architectural drawings were, he had dead-end corridors that were too deep. It was a bill that should be sprinkled and it wasn't. You know, there's a lot of things that could be a problem there, especially on a church over 300 people. And if since it's over 300, that's the reason he had to send it to the fire marshal. He probably wasn't aware of that until somebody called his hand at it.
Alton?
Several things. One, I think Steve had mentioned that he felt like maybe this individual had been hired by the contractor to do that, to perform those services. So any testimony that the contractor provided that he felt like it was a good service, I would disregard. Second thing is, the respondent provided a response and stated he has considerable experience with similar projects, which implies he's done this a number of times at other locations, so he may not have been doing it for the benevolence of doing it for a church that he is a member to. But regardless, even if he was, the fact that once he recognized I might be in trouble here, when he got to the submittal process and understood the level of review that was going to take place, he pulled out then, implies that even he recognized I may not have the competence level to actually have taken this on. So to me, that would be sort of an aggravating factor that he took it in the first place.
Thanks. Any further discussion? We have a recommendation before us. I'll entertain a motion.
I'd like to make a motion that we accept the recommendation of council, but we also add taking and passing the rules and laws.
We have a motion on the floor.
A second.
And a second. Any further discussion? Seeing none, all in favor?
Aye.
Opposed? Ayes have it. Motion passes. That is the end, unless, Stuart, you have anything additional?
We do have an addendum that was submitted, I guess, a couple days ago, and I believe it's on the iPad. It should be next.
So my hard copy printed yesterday is not going to work for me.
If you have a hard copy, that's fine. Just want to make sure everybody has the addendum.
On page 43.
43.
Of the iPad.
Stuart?
On the addendum, we have one case, 2016-053-951. This was first presented to the board in February of 2017 with the following summary. Complaint opened following receipt of information indicating respondents' stamped architecture plans, possibly outside respondents' area of competence as an engineer. A review of the plans stamped by respondent shows some concern regarding code knowledge and understanding of architectural process. History, none. Original recommendation, authorization of a civil penalty in the amount of $500 to be settled by consent order or formal hearing. Respondent also to complete law and rules examination. The board decision, authorization of a civil penalty in the amount of $6,000, which is $750 times 8 stamped pages, to be settled by consent order or formal hearing. Additionally, respondent must take and pass the law and rules examination. An update was made in February of 2018. This complaint was sent by a competitor indicating respondent had performed work outside her competency. Respondent had drafted architectural plans for a small 2-story rental unit. This case was originally presented by attorney Matthew Reddish, and the plans were reviewed by Rick Thompson. Mr. Thompson noted a number of deficiencies in the plans, including a lack of guardrails on stairs. As a result, the board assessed a civil penalty in the amount of $6,000, representing $750 for each architectural sheet respondent sealed. After Mr. Reddish left and this case was transferred to new legal counsel, respondent obtained legal counsel and requested the ability to explain her competency to a board member. In the hopes of facilitating settlement and bringing clarity / background to this matter, legal counsel arranged for respondent to meet with Mr. Brian Tibbs for questioning regarding competency in architecture. At the informal conference, respondent explained that she had designed 2 identical apartment buildings within the city limits and that she did not have any complaints. Respondent provided a recommendation letter from the city building officials. The plans in question for this complaint were produced for a building in the county jurisdiction and therefore subject to review by the State Fire Marshal's Office. Respondent stated the requirements seemed much different and more restrictive than the city. Respondent indicated she believed she was competent due to the 2 prior builds and the ease with the city in having those plans approved. Respondent has never worked under the direct supervision of an architect. Respondent stated the small student apartment work stemmed from small metal building design she had conducted. Respondent works with the same contractor with the same plans and modifies them to the space as needed. Respondent did state that issues arising from construction on this project led to the necessity to add the plans. This included adding stairs that were not anticipated due to construction, beginning a different elevation without consulting respondent. The original plans submitted by respondent show a number of comments and requests for revision from the State Fire Marshal's Office. After edits, the plans were eventually approved. Mr. Tibbs reviewed the plans after the informal conference, meaning 2 of our architect members have seen the full plans at this point. Mitigating factors. 1, previous identical builds were approved in construction within the city without incident. Aggravating factors. 1, review by board members showed missing elements from essential code requirements such as ADA compliant stairways. 2, original plans submitted required extensive revisions and had numerous comments from the State Fire Marshal's Office. The recommendation at the time was discussion. The board decision was authorization of a civil penalty in the amount of $6,000, which is $750 times 8 stamped pages, to be settled by consent order or formal hearing. Additionally, respondent must take and pass the law and rules examination. The new update. After a detailed review of this case, it is recommended that this case be closed with a letter of caution. The complaint was filed 2 months after the building was completed. It has been nearly 3 years since this project was completed, and no complaints or concerns of the health, safety, and welfare of the public have been raised. Respondent submitted the plans to the Tennessee State Fire Marshal, whom reviewed and made revisions in order to be compliant. Respondent made the necessary plan revisions, receiving approval, and the building was constructed without any danger to the health, safety, and welfare of the public. All concerns at the time were speculation of what could have caused a dangerous situation without review from the State Marshal's Office. At no time during construction of this building was the public in danger or potentially in danger. Construction on the subject issues of this complaint could not have been performed before the appropriate approval from the State Fire Marshal's Office. It should also be noted that respondents submitted plans for 2 previously constructed apartment complexes that were approved and the buildings constructed with no concerns or danger to the public. Also, the City Codes Director stated they have worked with respondent on similar projects and never questioned respondent's competency in the performance of work and has actually referred work to respondent. A recent conversation with the respondent's attorney revealed that no other projects that might require architectural work such as this have been submitted or performed since. Respondent's attorney further stated that no architectural work will be performed by respondent. There is no doubt that respondent should not have stamped and submitted the architectural plans in question. Respondent was not a registered architect, only a registered engineer. Respondent believed the architectural work was incidental to the work on this project as a professional engineer. There is indication in the file that respondent has had some experience and knowledge of architecture, IBC codes, ADA codes, and other applicable codes. However, respondent should have consulted with a registered architect. Respondent understands the mistakes made and has made no attempt to perform any architectural work and coordinates with the appropriate registered professionals. Mitigating factors: previous identical builds were approved and constructed within the city without incident. 2, no history of incompetency. 3, some experience and knowledge of architectural and other appropriate codes. 4, no complaints or concerns raised regarding public health, safety, and welfare. 5, plans revised and passed. Aggravating factors: respondent not a registered architect. Recommendation: close with a letter of caution and respondent passed law and rules examination.
Thank you. Brian, any additional thoughts?
I was thinking about this case when we were talking about the last case, actually. So I guess they represented it, and that's where the amendment came to ask for a lesser sentence, I guess, or lesser fine.
Well, the legal division looked at this case and reviewed it in detail, and it's 3 years old. And so nothing has happened in those 3 years. Nothing happened before, and nothing happened after. And so the division is looking at older cases like this to see if there's a way to justify some type of closure to resolve these cases. It doesn't mean that we can't close all of them, and we want to close all of them. It's that some of these cases are in civil litigation and have been for years. And so we can't close those. We also are not going to close anything that looks like there was a health, safety, welfare issue. But in this case, it looks like that the main problem was there were some architectural features in this project, and she stamped it, not being a registered architect.
Right. And she, well, I tell you the part that I was, most pleased with when it said that she stated that no architectural work will be performed anymore. I think that's the best part of it all. I guess this has been around for a while. I think Rick looked at it first, and I looked at it, and it's back again. As long as this part, I don't know how we could ever make her say so because of our state legislation that she not do architectural work. I'd feel comfortable with it, but I don't think we can say that. But the fact that in this report that she's not is definitely good. I think she just needed to stay in her lane using that. But anyway, I'll be interested to hear what Rick
I'd like to add.
Yeah.
I'd like to add that this respondent is highly recommendable in this area. Even Codes Department recommends this respondent.
Rick, since you reviewed the plans?
I did review the plans. I still stand by my opinion that she was not competent in doing this. And the simple fact that she had done some before doesn't mean that they were done correctly, and does not, if nothing's happened, doesn't mean something isn't going to happen. To just allow this to go away because it's 3 years old is not acceptable to me as a board member or as a registered architect. I will amend my recommendation if that's acceptable to the board. We have just levied fines for stamping drawings on other cases. So to get this in compliance with that, I would recommend that we assess a $1,000 fine. I believe that's the maximum allowed on that. Is that what we talked about previously?
That's correct.
$500 to $1,000 in staying with what we've just done to try to maintain some what's the word I'm looking for? Consistency. Thank you, across the board. The fire marshal did take exception to it. I took exception to it. The structural drawings and the architectural drawings were not coordinated. There were ADA issues. There were code issues. And she's admitted she was not qualified to do architectural work. And it's not a pass. She can't have a pass on this as far as I'm concerned. So I will amend my motion, my previous motion, and make a new motion that she be assessed a $1,000 fine, get some whatever letter of caution, taking past the rules, the law and rules.
So that serves as we have a motion on the floor.
Can we motion, can we even vote? I don't think we can even vote or vote.
So they can't.
Yeah. Just,
Why can't I vote? I did the original review.
I did the review too. I thought we couldn't do it anymore.
You can make a motion.
I made a motion.
I'll second that motion.
I believe that you can vote, yes.
Thank you. We have a motion on the floor and a second.
I will go on record that I support that too.
Any further discussion? Ricky?
Well, I agree with Rick's comments, and I think this is really dangerous, and one of the main things we're supposed to be doing as a board is keeping people from designing apartment buildings where people live who don't know the code. And I work in the building code all the time as a mechanical engineer, and I'm telling you, I don't know the code well enough to do the architecture. I know that on an apartment building, and it was proven here that this person didn't either. And the mitigating factors, to me, are not mitigating factors. As Rick said, the point that there hadn't been any safety and health and welfare issues is not a mitigating factor. That doesn't say there weren't things done incorrectly. And the write-up makes it sound like it's okay to do an incomplete design and have the state fire marshal catch it as an official reviewer. They don't have any design responsibility. The state fire marshal is not a designer of record. The designer needs to know how to do architecture. If they're going to do architecture, they need to have worked under an architect and really understand. So I guess your motion is to reduce the overall fine to $1,000.
Yes, in lieu of dismissing it totally and being in compliance with the other fines, and that's my motion.
Well, I would go with whatever you said there, but I think it's important that there be a fine for this kind of activity, this is more dangerous than not renewing a license.
Alton?
Yeah, I don't think just because somebody says, my bad, I learned my lesson, I'm not going to do this anymore, excuses what they did in the first place. The second thing is the fact that there were apparently a number of revisions and a number of submittal processes that this individual went through, and the state fire marshal's office kept having to catch those and apparently maybe making recommendations for compliance requirements indicates a lack of understanding of the codes and therefore an indication that they were practicing outside of their competence if they weren't aware of those codes to start with. And the third thing is one of the mitigating factors is she, and again, no offense here, but just because she was recommended by the local codes agency, she may be the only person performing that service out there for all we know. And that's not always indicative of the fact that they are competent to provide that service. And I agree with Rick, and subsequent to that, Brian's recommendation and all of the things that Ricky said also.
Susan?
I'll step on some toes. The fact that it's taken 3 years is not this board's fault. The fact that you all have more work to do than you can get done within the legal department, to me, is a separate issue, and maybe that's not the issue. But when it takes 2 years to get a newsletter reviewed, and then it's no good anymore, there's some other issues going on, and that's not part of this case. I still think we need to be consistent. And, I'm not an engineer and I'm not an architect, but I'm going to go back to my little, stand of we got to be consistent. And if we let one go, then what's going to happen when the next one comes along? That's all I have to say.
Thank you. Any further discussion? We have a motion and a second. No further discussion? All in favor?
Aye.
Opposed? Ayes have it. Motion passes. Anything additional on the legal?
That's it.
Great. Thank you very much. If we can take a 10-minute recess, and Ashley, we'll see that you're in the You're here, so we'll give you first up. How about that? Thank you.
Good morning.
Morning.
Ashley Cates, AIA Executive Vice President, and I'm here to give an update on all things that are going on within AIA. So we're gearing up for the 2020 legislative session, and we are going to be supporting the state historic tax credit legislation again for 2020, and hoping that this is the year, and really working with a good coalition to move forward on that effort. And so stay tuned for more updates throughout the year on that. And then we've also got a really good some materials on professional licensure through the coalition that's advocating for professional licensure. And so I'll send any additional materials that we receive through AIA National to you all for your information and use if we have to use it in the upcoming legislative session, which hopefully we don't. So those are the two main things that I have on the agenda. We're going to be in Nashville for the conference next year, and it's going to be July 15th through the 17th at the Hilton. And our Down the Hill is March 3rd. We're going to do it in conjunction. We're going to have a legislative reception in conjunction with the engineers and the contractors again. So, but our legislative Down the Hill will also be on March 3rd. And right now we're just kind of monitoring. We'll get our government relations group up beginning of January to start monitoring legislation. So that's what I have on the agenda. I also reached out to Brian and Jennifer regarding the rules and just a few concerns about the carryover hours, and I think y'all are going to talk about it a little bit later. So other than that, that's all I have.
Great. Thank you. Director's report, Jennifer.
On page 47 is the rule that was presented to the engineering committee yesterday, and the engineering committee accepted Mr. Bursai's changes and made one more change at the request of Mr. Campbell to include the word nuclear in one of the paragraphs. And so what you have in front of you, so on your iPad on page 47 was the rule in its form before yesterday, and then what you have paper copy is what we're calling definition 7.0, and this is the working copy, the latest and greatest on the engineering definition. That definition, once legal and I are able to consult, is going to be presented. I think Ms. Casey Anderson has a copy of it. She's kind of looking at as you all look at it, but that's going to be presented to Ms. Anderson. Ms. Anderson has generously offered to send that to necessary and interested parties for feedback and compile that feedback and then provide that to me and to the board. So we are definitely moving forward on that engineering definition.
I just think we should ask Robert to say the word nuclear.
Do we need a motion?
Nuclear.
Thank you.
Okay. And then that moves to my understanding from prior to my working here is that there were a couple of definitions that had already been agreed upon, and I just wanted to double check with the board to make sure that everyone was on the same page, that those definitions were ready for the same process. The first one on page 49 on your iPad is the landscape architect definition. We have CLARB's definition and then the proposed definition, and I just wanted to make sure that this is still current and this is still what everyone wants to move forward with.
Yes, this is still current. The Tennessee chapter of ASLA, when they understood that NCARB, it was going to take a while for NCARB's definition to come out, they would also like to vet this through national ASLA just to make sure that everybody feels good about it. So as of this moment, I would say yes. There may be minor modifications here or there. Does that affect the process any?
No, for my clarification, has this gone out to everyone? Has this already gone through the procedure that Ms. Anderson is going to do for us on the engineering? This has already done that? Okay, so we're ready for legal, and we can talk about moving forward that with legal. Okay. On page 50 of your iPad is the interior design definition. I just wanted to make sure that we were all on the same page, and just if you would confirm for me that that has already gone through the process. Oh,
Yes.
I think you're not on.
It's only the top paragraph.
Perfect.
Okay.
Thank you for clarifying that.
Right, Susan? That's the,
Well, actually, we added the practice of, to the extent that, in the second paragraph, which I have right here. This is the one that our committee approved. So
that was one you were asking me for, Jennifer, that I
Yeah.
said Roxana had. Do you want to get that one?
Yes.
Okay.
would you like to make
Yes,
a copy?
please.
We did that so that each of the definitions had consistency with our opening sentences, so.
Okay, so it's just the first paragraph, though.
No, it's what's on that sheet.
So not the first paragraph.
Well, this is what was issued by CIDQ, and then we added the words in red.
Okay.
Which was approved by the committee prior to you coming on board.
Okay, so this is in place of the first paragraph.
Correct.
Okay, perfect. Thank you for that. And then I'll get with legal also on this definition so that we can move forward. My understanding, Mr. Parker, is that architecture definition is in limbo, awaiting more of a national movement.
Yes, my understanding, we're waiting on NCARB's amended definition.
Right, they've gone through one iteration and one feedback from the general population of the architects that are NCARB certified. And I didn't bring it with me, but they've got a second version. I guess like the engineers, they're at 7, but this one's at 2. But anyway, the architectural definition, I don't plan to bring to the board until after the annual meeting in June. And so I'm not trying to slow down or delay. I just wanted to get it right.
Okay. All right. On page 54 of your iPad, in October, we talked about an email that would go out, that would be generated and sent out to the licensees, reminding them if they were in an expired grace period, that email went out. And so this is just for the board to see a copy of the email that went out. And now might be an appropriate time to mention the newsletter. The outreach committee did not meet, but we can still begin working on the newsletter and sending drafts and talking to the outreach committee prior to the February meeting, and hopefully we could have something by then. Wanda G is one who would normally help with those kinds of things, so we're excited about her training the next person that's going to fill the very big shoes. But so that is, I don't want the board to think that's not on the horizon or that it's been kicked down the road. It's definitely coming. It's just a matter of, it may be a bit more condensed than it may grow to be bigger and better, but I think initially a more condensed version is probably going to be best, and then grow forward from there. So, all right, so then we have the budget, which is on page 55. And then on 56 as well. Page 56 reflects the board's decision to increase the grant funding from $350,000 to $400,000. So that's great to see on there. Yeah, that's great.
That's effective 2021,
Right.
correct? Okay.
Yes. Along those lines with the grants, you also have printed out for you some information regarding the Lipscomb grant. So, do you have that, Ms. Beth?
I got it, but I hadn't prior knowledge to what was going on.
Well, and this is just, I handed it out. This is in addition to the what's on your iPad. So you have this document. So it's my understanding that for 2019, there was some turnover in the department with Lipscomb, and so what was actually spent was not what was allocated. So it was very descriptive as to what could be purchased and what could be how the funds could be used. And because of the turnover and some miscommunication within Lipscomb, there was it was used for other things, and so Lipscomb refunded that portion because they couldn't actually use that grant money for the things that they spent it on. So to be in compliance, they refunded that money, and so what they are requesting, and that is approximately $12,900. And they have the sheets following that top page. They break down, and they have a letter on that second page where they're explaining things. And then they have a breakdown for exactly what was spent and why it was spent and how it directly affected the students. And then they have asked for in 2021 the amount of $19,970. The board approved $14,911. Roxana and then Sherelle with the grants, they have reviewed everything that was spent, and they appear to be in line, and again, for the benefit of the students, directly affecting the students. So what the request from Lipscomb is that the $12,900 that they have already refunded, but they did spend, be added to the amount, which would be a total amount requested of, and we've amended it from what they had. You can see Roxana struck through that, a total amount of $27,811. And so my understanding from Sherelle is that that's within the purview of the grant of the board to be able to do that. We just need a motion on that and approve that amount.
So moved.
Well, hang on a minute. We need a grants committee to talk about it briefly. So I don't know if we need to recess for a few minutes and have a grants committee meeting, or I know it's less money, so that's not a problem, but we've never had this situation before, and I want to make sure everybody on the committee is in agreement. So
Suspend our meeting for a moment and shift into a grants committee meeting.
Do that without sunshine.
Can we do that? Sorry, caught you off guard. Okay.
Sure.
All right.
Maybe I'm just confused about this. Can you explain in redneck terms what you just said? They were, I think, the original application, the way the allocation was made, they got $11,785 plus an additional allocation beyond that based on this pro rata distribution share. Did we wrote the check for the total amount, which included the $12,900 for the pro rata share, and what happened to that?
My understanding is that when we received the receipts or showed what they spent it on, it wasn't on what the grant contained. So the grants are very specific as to what can be.
Correct, yeah.
And so it wasn't, because there was some miscommunication within the department. And so in order to be in compliance, they had to refund the money because they didn't actually use it.
That portion of the money.
That portion, even though they used it, they didn't use it on what they were supposed to, so technically they didn't use it.
Right.
So they had to refund that money. So we certainly do want to, because they used it for the benefit of the students, we want to help them if we can and just add that to their grant amount.
So this is a re-request. Have they changed the scope so that everything is allowable now?
Yes.
Okay.
And they provided, all that they provided here, this addendum, it itemizes and shows exactly how it's being spent, why it's within the scope. And then they're asking for that money on top of the grant that they had previously received.
Thank you. Okay, and with the they've already paid that portion back, the $12,900. Now they're re-requesting under the format that is allowable. Everything is
Correct.
allowable. Okay.
Correct. And
Very
added
good.
to 2021.
Thank you.
We need the committee, I
Yeah,
guess.
that clarifies. I thought they were asking over and above what they already had, but since they've refunded and it's just being
They did refund it.
reshuffled back out. Okay.
Correct.
All right.
As a committee member, I'd like to make a recommendation that we accept the modification
Yeah.
as presented.
Second.
Right. So, the Grants Committee would like to make a recommendation to the board that we accept the changes as submitted and reallocate the money back for the students' examinations. So, okay.
We have a motion on the floor. We have a second. The Grants Committee agrees with this. Any further discussion? All in favor?
Aye.
Opposed? Motion passes.
For me who the motion was and who the second was.
Well, the Grants Committee motion, I made the
Okay.
motion, and then Brian seconded.
Mr. Tibbs, okay.
Yeah.
Thank you.
Not present it to the board as from a committee recommendation.
Thank you.
Okay.
On page 57, this is where the board just needs to approve some travel to go to some conventions and things. The first one is
It's for you.
and how do you say that? Is it CIDQ? CIDQ. Okay, I didn't know from. So CIDQ, yes, it's for me, and that is February 12th through 14th in Washington D.C. and that is specifically for board members, new board members, and executives for architecture, interior design, engineering, landscape architecture, and surveying within the last 2 years, which I fall nicely into that category. So
This is a sponsored trip, so that's the other good thing is, but it was on a first come, first served basis. So I wanted her to know about it as soon as they announced it so that she can have an opportunity to go. So I make a motion that we approve the expenditure and time for Jennifer to go to this conference.
We have a motion and a second by Brian. Any discussion? All in favor?
Aye.
Opposed? Motion passes.
on your iPads, page 58 is the NCARB Region 3 conference, and that is March 6th through 8th in Cambridge, Massachusetts. So we just need approval on that for travel as well.
I'd like to make a motion that we accept that or make that available, that travel.
Motion on the floor.
Second.
And a second. Further discussion? Seeing none, all in favor?
Aye.
Aye.
Opposed? Ayes have it.
Excuse me, I'm sorry. Do we need to move forward with the June meeting as well, the annual meeting for NCARB?
We can, certainly.
Or whatever the pleasure of the staff and board. It's just on the. It's on
June
the,
17th through 21?
Yeah, it's just on
Sure.
on the sheet.
I might as well.
Wouldn't it make sense to go on and issue all of those?
Yeah, well, sure.
Yeah.
Could I, do you have to approve how many people are going when you do this right now, or how do you do that usually?
We have typically set up to a certain amount, up to a certain amount.
To a certain amount. Okay.
And as an example, for NCARB, it would be the 3 architectural board members and 1 or 2 staff members.
Okay.
Either you and an attorney, or
Right.
you and someone of your choice, or maybe an attorney, or just
Okay.
you. So it could be 4 or 5, 3 for sure, but
Even the public member.
even a public member is welcome to go to the
Okay.
NCARB meetings.
Okay.
So it could be any, you could approve 5 or 6, whatever.
Rick, just a quick order question.
Yeah.
Does the department, I know, for example, on the NCAAS travel, the department weighs in on the number of people that they will actually reimburse.
Well, this NCARB pays for a number of the attendees, and the majority of the attendees that will go. I think typically they've paid for the 3 architects and the executive director to go, and or a representative. Now that doesn't mean that they won't pay for more, but that's the expenditure to the state is minimal.
Jennifer, this is Robert. You need to go ahead on everybody, get clearance on the number of people we can take, whether it's paid for by CWS, NCARB, or whoever. We've had some pushback in the past, even though it was funded by the organization. Not suggesting any of these do, but we've done that in the past to get their exact number.
Okay.
One last comment, Frank and I conferred this. In the past, NCARB has done 3. They pay for 3 members, and the state has funded 2, up to 2.
Okay.
Yeah, so we would think 5 would be our approval number.
Okay.
But you're only requesting state funding for 2 of those.
Well, I think we have to ask for permission for all of us to attend. So it's approval for the members of the board to attend, regardless of how it's funded. So
You're both right.
Yeah. So yes.
And I presume for the CIDQ, only 2 members. I mean, maybe myself and Maria, or since we're both new or something like that. I wouldn't presume we need more than 2 at the CIDQ.
I think that'd be fine.
Okay.
I can tell you that I have attended that, and you're welcome to go.
Okay. I look forward to it.
Yeah, it's a good meeting.
Okay.
Okay, so we have a motion. Is this a motion? Do we have a motion yet?
No.
For this?
No, we don't.
For the architect,
For the travel.
for the NCARB, which I believe is
we made a motion on the March meeting, but then that's the question was, do we need to do more than just that? Because we didn't approve a number of people for the March meeting. We just had made a motion that we approved the travel.
So we do need a motion then for the next meeting.
I'm sorry, did we make a motion?
I don't think we've done motions on
Okay.
any of them. Well, no, maybe I think the first one we did.
Yeah, and could we just amend that motion? Are you okay with that? A friendly amendment, sir?
Yeah.
Yes, please.
Or just make another
Or
motion.
just make another motion. God, I'm sorry, I'm getting hungry for lunch here.
Just do it.
I'll make another motion. Thank you, Brian. I'll make a motion that we approve the travel for the architects and state staff members up to 5 to attend both the NCARB Regional Summit meeting, which is March 6th through the 8th. That will require travel prior the 5th and travel back on the 9th, most likely. So I'm not sure how that's to be determined. And also, I'm making a motion to approve, or add to that motion, add the June annual NCARB meeting for 5 members to attend, 3 board members and 2 state staff members. And that meeting is 17th through the 21st. And again, that will require a day of travel prior to the 17th and most likely a day after the 21st. So that's my motion.
So we have a motion on the floor.
Second.
And a second. Further discussion? All in favor?
Aye.
Opposed? Thank you. Motion passes. As far as landscape architecture and the CLARB meeting or whatever, I would like to bring that back to the next meeting and have all that information prepared by then. So at our next meeting in February, I'll bring that to the board. And if there's anything else additionally from the other organizations, we'll do likewise. Fair?
Perfect. Thank you.
Okay. Okay, I think that's it for the director's report. Thank you very much. Committee reports, Outreach Committee.
Outreach Committee didn't meet. We'll meet in February.
Thank you. So if we'll put that on the agenda, please. Engineer Committee.
Well, we met and met and met and met. In fact, I'd like to invite everybody to come attend our meetings. It's interesting and long. It is that at least. We had a number of reviews for licensure or licensure renewal. We had one interview and actually 7 different specific requests to review. We took action on nearly all of those. Some we requested some additional information from legal that will be resolved, I'm assuming, at the next meeting. In addition to that, we discussed a number of different issues related to path to licensure and licensure. We know that we've got at least 4 elements that are either in place in other states or being considered by other states that will affect licensure in years to come. One is the engineering technology degree and how we manage that. 2 is the decoupling issue. 3 is an undergraduate degree in non-engineering field, but then a master's degree in engineering and how we handle that. And the 4th one is the international degrees. So, and thanks to Casey, who was at our meeting and usually is at our meeting and has really good input and recommendations, rather than try to tackle all of those individually, what the engineering committee has elected to do with Casey's help and guidance is to try to look at them cumulatively and handle all of them simultaneously so that we don't do things in piecemeal order. Some of the things may actually not be a change to our laws or statutes that we may be able to get implemented, or in fact the laws or statutes may be easier to get implemented in a more timely manner. We'll decide that later, but we're going to try to develop a plan of approach for how we assess and determine what language we need to consider and or adopt or not adopt for each of those 4 elements, or at least there's 4 right now. And that we spent a long time on all of that. So, and we were all tired after the end of the meeting. So, thank you.
Thank you. Laws, rules, policies.
Yes, we had a meeting this morning, and primarily what we discussed, and we've discussed this previously, is the rollover. I think it's amendment number 0120-01-.08, and it's one of the amendments we were making to the amount of CEUs that the architects need, or we would want to amend from eliminate the carryover hours because of various states not allowing those, and it hinders our registrants from practicing outside the state. So we've asked, or legal has volunteered to get with NCARB and get some statistical information for the board to consider, and that information could be utilized in explaining what we're trying to do to the either legislative body or whoever needs to know about why this is a good approach. So that's simply it. I don't want to belabor it. If you have anything to add, I would appreciate it.
I think that about covers it. One point we did discuss is that initially when we had scheduled the rulemaking hearing for today, we were getting a lot of pushback and public comment. And so having the knowledge of what other states do and the carryover and why some people in Tennessee might be resistant to that was helpful and gives us a good approach. So we'll definitely be in touch with associations and move forward. At the next meeting, we'll have language that you all can review.
When you mentioned public input and complaints or whatever, how do you receive that? Is that coming through emails, phone calls?
So statutorily, we send out the e-notifies that we're required to do, and I put my contact information, and usually licensees will, or just interested members of the public will respond back to me, and they'll give me just, their stance on the rule, why they disagree or why they agree, and so we got a lot of that for this rule.
Any input from up on the Hill?
No, not at this time. Just because I'm not sure to what extent they may have or have not, got notification.
Thank you. Mm-hmm. Any additional questions, comments?
Frank was first.
Oh, Frank.
Yeah, I guess the question would be the kickback that you got. To me, there's 2 major things in this change, and one of them is that all the hours will be required to be health, safety, and welfare. Is there any pushback on that?
I think there may have been one individual who mentioned that, but I think the main issue we ran into is that the rule stated a 2021 cutoff date, and at the time it was drafted, that was fair and equitable to all the licensees. And at this time, because the time has lapsed, and I do apologize on behalf of all my people who have gone before me on this, but that was just a huge piece that was not fair. We couldn't go forward with it.
Right. And the other part of that, it's my understanding the carryover seems to be the biggest complaint. And by extending this a couple of years, wouldn't that pretty much resolve that?
I think we might have individuals who are not pleased with the fact that carryover will not be available anymore. However, like I said, Rick gave a really great explanation as to why we would be on the same page with other states, and that would be a good thing.
That's right.
I think the main piece is that it's going to be fair to all the licensees. So whether or not you renewed in 2019 or 2020 or 2021, you're going to have the same advantage that maybe someone on a different renewal cycle has. So you're not getting treated unfairly.
Yeah, since our renewal cycle is 2 years.
Yes.
It's the simple thing.
Thank you. Any other comments, questions? Yes.
One, while we're all still here, I want to take the opportunity to express all of our gratitude and thanks for a significant contribution and term of service to this board for both Wanda Garner and Francis Smith. We all owe you a significant debt and a tremendous amount of thanks for the level of service and professionalism and excellence that you provided to this organization. Tremendous loss of institutional knowledge, but more than that, loss of dear friends and very, very, very valued individuals. So thank you. We'll miss you, and good luck in your retirement.
Thank you, Wanda. You will sure be missed.
Back at you.
Okay, that concludes our formal agenda. Anything additional?
No, it doesn't.
It does not?
I
Oh,
have my report.
I'm sorry.
Yeah.
So the noise that you hear, the noise is, I've bought us another 5 minutes.
Okay.
So
It's
I told them noon, and they started exactly at noon. My goodness. So I have a feeling they're going to be prompt.
It will be brief, I promise, because it's lunchtime. So this is my last CIDQ conference, and they've always been very good. And it was in San Antonio, which was a wonderful city to visit, but I flew in, flew out as fast as I could because I was getting married the next weekend. So anyway, the CIDQ will celebrate 50 years next year, which is a significant thing. In the last year, they've had a 17% increase of certificate holders that have passed the exam, which is great. The International Interior Design Association is supporting the term interior designer, not interior architecture. So I thought that was a significant statement. And another important thing that was presented to us is that NCARB and CIDQ are working together to review examinations to make sure that we are both current in what is going on in the community and professional world at this point in time. We also had NCARB, NICI, and CLARB attendees at our meeting, which I thought was great. This is the first time we've had everybody. We had two excellent speakers. One was Bill Boshi from HOK, which talked about the challenges of our upcoming workforce and the lack of communication skills that they have. And so I had an opportunity to talk to him after the meeting, and I could also chime in with what he had to say. The other one was David. I just went blank on where it's David Smith. He is a lobbyist from Florida that helped kill the deregulation bill, and we all face deregulation issues. across the country. And I think the important part was that multiple groups are working together to meet these challenges. So again, a very good meeting, and I will miss the group of people there. They're the cream of the crop, and they're excellent, and they are friends. So that's my report. I'm done.
Fantastic. Thank you. Okay, that concludes our agenda, unless there's anything additional.
Well, let's break for lunch.
Let's break for lunch. We have a motion to adjourn. And a second. All in favor?
Aye.
Thank you.
Yeah, Robert, see you there.